May it please your lordship. Lordship, I beg to mention one CRP IO for listing tomorrow, lordship. Some urgency is there. Motion matter, lordship. Tomorrow, lordship,
Tomorrow
some
not possible.
lordship,
Already 48 meters, 40 meters.
very urgent matter, only
Maybe.
motion matter, lordship.
Sorry.
Otherwise, lordship, on this ground, again, my CRP
Sorry.
will be dismissed, lordship. Then day after tomorrow, lordship.
Okay, day after tomorrow.
Obliged.
May I please your lordship? My lord, one RSA matter, my lord, of 2015, my lord. Matter may come up for hearing, my lord, on April 22, my lord. Or my lord, 24.
24.
My
May it please your lordship. Lordship, I have filed an IA today, your lordship, seeking in a pending CRP, seeking its listing tomorrow. What happened, your lordship? The CRP is pending regarding the suit land. In the meantime, the respondent authority yesterday served me a notice seeking eviction from the suit land day after tomorrow, your lordship. If the matter is not heard, the CRP will also become infructuous, your lordship. Kindly, your lordship, since it is an eviction matter, your lordship.
Not possible. Day after tomorrow.
No, day after tomorrow morning, they have given time, your lordship. By the time the matter will be taken, kindly, your lordship, I will try my luck, your lordship, tomorrow. Since eviction matter, lordship, I have,
As a last item, we will say.
lordship,
Otherwise, day after tomorrow.
tomorrow, your lordship. Last item, I will try my luck, your lordship.
May I please,
Obliged.
your lordship, I beg for listing of an RSA matter. It's a long pending matter since 2013
In which column?
in hearings.
Hearing. Take it that one.
May it please your lordship, I beg to mention one RSA for listing. On earlier occasion that the matter has been already fixed for hearing.
When do you want?
List on a hearing column.
When?
Next week maybe.
Next week. After vacation, you take it that one.
May I please, your
Yes, madam.
On list.
May please your lordship, regarding item number 20, lordship. I am for the appellant, lordship. This matter was heard by the Honorable Justice Parthavjyoti Saikia, lordship, and it was made part heard, lordship, on 5/10/2023.
Item number 20.
20, lordship.
Okay.
This is the order of
Not
5/10/2023.
necessary. Okay. Recessal list the matter before appropriate.
Obliged, lordship.
Next week, date may be fixed, well, next week. It's been,
You are in the bench.
yes. I am on the, for the respondent, and it's been more than 1 year, the matter has been kept as
So,
part.
Mr. Biswas, it is unfair on this, on part of this court to fix it that to be listed before another court.
Otherwise, my lord,
Next week, lordship, lordship can mention it next week, lordship. I have no objection.
your lordship may mention it, but it never comes, my lord, next week. Again, we have to mention it before the appropriate bench, then again, it will roll back to another week, my lord. This is the problem. And this is a case of specific performance of contract. My client has invested more than 50 lakhs. And now neither he is getting the money nor he is getting the land.
Okay, as
And
soon.
regarding partner matter, there's a rule that more than 1 month, my lord, a matter cannot be kept as partnered. So it's been more than 1 year, the matter has been kept as partnered.
Only I have to point out this code.
Yes,
That's what I'm
yes.
pointing.
I'm not objecting to that.
Hmm.
A date may be fixed to be
Definitely date.
next.
Okay, as soon as practicable, we will not fix it.
We don't know, my lord, when it will be practicable. This is the.
No, rest they will take care of the same. If the matter would have been of this court,
Yes, yes, I
then I would have fixed the
understood.
date, but not before another court.
Obliged, lordship.
may I please, your
Yes.
lordship? I am filing, I civil filing number 307 or 3705/25 and 3704/25.
When do you want?
This case has been already been settled in last Lok Adalat court, lordship.
Okay.
Awarded record amount is bigger than
No,
Wo-
when do you want?
listed for lordship 28/3/25 for settlement, lordship.
Okay. No, when do you want the matter to be listed now?
Awarded record amount is bigger than both the parties. 28.
Okay.
28.
May please, lordship, I beg to mention for item number 21, lordship.
Yes,
I have taken consent from the other side, lordship, kindly adjourn for 1 week, lordship.
1 week. Do you have Mr. M. Ahmed?
Yeah, Hussein Lordship.
M. Hussein, learned counsel for the appellant with consent from the other side, press for listing the matter after a week. Bear alone.
The
Yes.
Lordship's indulgence, my lord, I would like to mention two items. It may come up for order on next Monday. Monday, 1st April,
That's the page.
1st April.
Okay, take it from him.
My lord.
My lord, with the consent of the other side, my lord, I beg to mention item number 16. of
1/6.
1/6. May I pray that it may be taken up after Bihu vacation, my lord? Maybe in the month, first week of month of May.
Learned counsel for the appellant with consent from the other side, press for listing the matter after the vacation. Bear alone.
May it please, your lordship.
Yes.
With the consent of the other similar, I beg to mention item number 9, my lord. I'm for I'm appearing on behalf of Mr. E. Chaudhary, my lord, advocate for the respondent number 1. So he has some difficulty, my lord, some rituals.
Item number 9.
9, my lord. That will be taken up on
So the name of the council is not there in the
petition.
list, cause list.
Sorry, my lord.
Name of the council is not there in the list.
It's not shown in the cause list, my lord. Mr. A. Chaudhary, my lord. His name is not there in
Mr.
the
Khatunier, learned counsel appearing on behalf of Mr. Sodhuri.
Chaudhary. A. Chaudhary.
Yes, Sodhuri, learned counsel for the respondent with consent from the other side. press for
My lord,
listing the
I'm
matter.
appearing for the petitioner, my lord. I'm appearing for the petitioner, my lord, in this matter. Yes, ma'am.
Okay.
My
When do you
lord,
want, Mr. Khatunier?
I'm praying for 7, my lord. He's
my lord, on fourth,
fourth,
my
my lord.
No, you settle the
It's
matter.
okay. If he's insisting, my
Seven.
lord, I'm not objecting to it. my lord.
7. Okay, as agreed
Yes,
by learned advocates of both the parties, this is the matter itself.
My lord, if I may, matter may be fixed as part heard, my lord. Your lordship has already heard the matter.
Is it a part heard matter?
No, my lord, it's not part heard, my lord.
My lord, on the previous occasion, your lordship had heard the matter. It is reflected in the order. And they had prayed for filing of an objection to that effect.
9 item. It is not a part heard matter, but there is an observation that the matter will be finally heard on next day. Okay. Part heard.
Deeply obliged.
Made teacher lordship, I beg to mention, and I along with her RERA appeal for listing.
When?
Your lordship, any date this week?
Next
towards- This week was Friday, your lordship.
Take it that.
Obliged. May I please your lordship? May I please your lordship? I should beg to mention item number 14, your lordship.
1/4.
1/4, your lordship. Your lordship, I have instructions that two of the respondents have expired, your lordship.
Okay,
Will file a substitution petition, your lordship.
okay.
Let
this petition be filed within 2 weeks, my lord,
2
because
weeks.
2009 matters, 10 matters.
Okay. As agreed by learned advocates of both the parties, this shall list the matter on when
After vacation, immediately after vacation.
immediately after reopening the vacation. In the meantime, you are for the appellant,
Appellant, your
the
lordship.
learned counsel for the appellant may file necessary petition for substitution of the legal heirs of
Respondent number 1, A,
respondent number 1,
A and B.
And B.
A and B.
B, my lord. My lord, kindly fix, it will be convenient, kindly fix to 22
Yes.
of April, after B,
Appeal.
April, my lord.
Much,
Right.
much obliged.
May it please your lordship, I'm going to mention for listing of an CRP matter, your lordship.
When?
Second of April, your lordship. Next week.
2nd of April.
Oh. Yes, your lordship.
Okay.
Obliged, your lordship.
Similar regarding midday meal, my lord, of ME school. Similarly, it was listed on last 10 February. So, my lord, may I pray it may come on 2nd of April, my lord.
May it please your lordship. Lordship, in this case, the client has instructed me to withdraw this matter. They have sent me a letter, lordship. This may be kept on record.
Part Ms. R. Soduri, learned counsel for the appellant, and Madam you for
D Devi on behalf of Vijay Mukherjee.
D. Devi,
Devi.
learned counsel, appearing on behalf of Mr. Vijay Mukherjee, learned counsel for the respondent. Ms. Soduri submits that she has the instruction to withdraw this appeal. And as such, Ms. Soduri submits that she may be permitted to withdraw the same. Where is allowed, this RSA is concerned disposal of one withdrawal. Is there any order, interim order?
No, no, lordship.
Okay.
There is one IA
Resistance
civil
return the
4060.
record. Resistance and back the record of the
IA
learned trial court. As
One
well as
IA is there,
procedural.
lordship, 4060. They have taken back all the documents from me, lordship, so I am unaware about what is the IA civil
In
4060.
view of order passed in the RSA number 142 of 2021, the IA number. IA is not listed to the
Lordship,
IA already disposed. Okay.
lordship. But my instruction may be kept on record, lordship.
Okay, the written instruction the learned counsel for the appellant received and further before the court today shall be part of it.
Obliged, lordship.
There is item number 1 for motion.
May it please your lords. My lord, it is a second bill application, my lord, bill application. And it is filed by only one petitioner. Earlier application, my lord, rejected by your lordship on the ground that time investigation was in preliminary stage, my lord. Now, my lord, here the police registered the case. Police registered the case, Tezpur PS case number 27 of 25. And that case registered under section 308, subsection 2, 3, and 5, my lord. Now I'm coming to the FIR, my lord. FIR shows that it is a case of attempt of extortion, my lord. And money demanded, and that money, which amount of money demanded, that was not delivered. So it is an attempt of extortion, and only on that ground, my lord, two accused persons, they have been released on bail by the learned CGM test, my lord, on that ground. That order I have annexed to it. So for the time being, my lord, city may be called for.
Please wait, the learned additional PP is absent now. Let him come. Wait for a while.
26.
May it be your lordship.
Hmm.
My lord, the petition under 227, my lord, brief
Hmm.
facts of the case is this, my lord.
So, against granting of adjournment.
Repeated adjournment in view of the High Court's directions. And thereafter, my lord, again, my lord, the Supreme Court judgments, because this is a matter of 2021.
Hmm.
Thereafter, they moved in 2023, obtain a stay order on the basis of a transfer petition. 2024, my lord, will kindly come to my lord, order dated 18/1/2024 at page 14, page 24. And this petition was disposed of and was dismissed. Thereafter, went back to
Transfer
the
petition was dismissed.
dismissed, my lord. And
Okay.
thereafter, my lord, case was posted for the first time again after dismissal on 22/2/2024.
Hmm.
And thereafter, we have filed an amendment petition that was allowed. They have not filed written statement. Date after date, my lord, for adjournment, my lord. That cannot be, my lord, in view of our High Court notification itself, my lord, if your lordships comes in, my lord. That notification part is at page 44, my lord. In the event of witnesses are present, witnesses are daily present, my lord, and they doesn't come in, my lord. And my witness comes in from, my lord, UK, my lord. They file an adjournment, my lord, adjournment sought, again gone, my lord. And that being the position of law and the Supreme Court judgment also I am relying on the basis of which this notification has been issued at page 46, my lord. And that's the mandate of law, my lord, under Act 227. Being a constitutional court, my lord, a direction may be given, my lord, that's all, my lord, to not to entertain further, my lord, adjournment and dispose of within a time limit. That's all I want, my lord, nothing else, my lord. And speedy trial is a fundamental right of a person, my lord. And very
No,
basic.
Mr. Bhuya,
Yes.
recently Supreme Court in the case of Allahabad High Court Bar Association versus State of UP.
Yes.
Supreme Court has directed that High Court should not direct the trial court to complete the trial within a time frame, definite time frame.
My lord.
That is deprecated.
No, my lord, what I am on is this. The law with regard to this has been simplified by many a judgment with this. Adjournment is not a matter of course.
No, that's all.
My lord, here the order sheet shows, my lord, adjournment over adjournment, my lord. Is it a matter of course, my lord? Wherein this notification has been issued by our High Court, my lord. In view of this adjournment, case will never go further, my lord, if these tactics are adopted, my lord. And in that view of the matter, my lord, expeditiously as possible, my lord, that observation been given. That's, my lord, no time frame may be given, my lord. I have not come across that particular judgment my lord is referring to. But what I am on, expeditious disposal of a case.
That is well settled.
Yes, settled. And adjournment is not a matter of course, is a law. And that's been on the basis of which our notification has been issued by this Honorable High Court. Then when witnesses are in attendance, no adjournment. If the adjournment is sought for, we appoint amicus curiae and do the case. That's been the speedy trial, my lord. That's observation can dispose it of.
Mr. Bhuya, at this instance, let notice go, let the other party enter appearance. Will pass necessary.
I leave it to your lordship, wisdom.
Party
Because
choice
this
will
Honorable
be-
Court has judicial as well as administrative power also,
Yes,
my
yes,
227.
Learned counsel for the petitioner. This petition under section 227 of the Act of Citizen of India.
Article
is prepared by
227.
the petitioner challenging the order dated 10/2/2025 passed by the learned Principal Judge Family Court, Kamrup M. Guwahati. Family Court number 3, Kamrup M. Guwahati in FC within bracket civil case number 342 of 2021. It is to be noted here that by impugn order dated so the learned trial court has granted adjournment of the case.
Repeated adjournment, my lord.
And further cross-examination of PW1, of course, subject to payment of cost of rupees 1,000. Mr. Bhuya, learned counsel for the petitioner submits that the learned trial court has repeatedly granted adjournment
Yeah.
to the respondent hearing. And the matter is pending since the year 2021. And as such, Mr. Bhuya has contented to issue direction to the learned trial court to dispose of the matter as early as possible. The submission of Mr. Bhuya needs further consideration at this stage. Let notice be issued to the respondent. Respondent returnable in 4 weeks that be taken by the state courts with AD and also by usual process. We can come to please the matter after 4 weeks.
For deeply obliged. Deeply.
Sorry, my lord.
What happened to you?
My lord, access road, my
Another
lord.
court. So what is the stage of investigation? Do
My
you
lord,
have-
for that, my lord, I have to call for the case study, my lord, kindly, because my lord, your lordship, my lord, that rejection order, my lord, that investigation is at the my lord,
Going on.
preliminary stage going on. So, my lord, the latest position of the investigation, my lord, we have to call for the case study. My lord.
In the meantime, my lord, my interim fair date may be kindly be considered. He will appear before the IO, my lord.
Because already it is rejected by your lordship after going to the my lord.
FIR not to speak anything about the commission of the offense, my lord, under section.
No, but
308.
as far as I remember, some materials are there
Yes.
against this person. Anyway, we'll see the stage of investigation.
Case
Or
diary
Mr.
may be called
DC
for, my.
K. Hazurika, learned counsel. For the applicant, Mr. B. Sharma, learned additional duty for the state respondent. This application under section 482 of the BNSS 2023 is prepared by applicant. Like Fauzuddin Nath, who has been apprehending arrest in connection with Tasspur PS case number 27 of 2025, registered under section 308, within bracket 2, stroke 3, and 5 of the BNS. Mr. Sharma learned additional PT summits that he may be granted some time to produce the case diary before this court. Where it is allowed, this is always the matter on. Sorry. 4th of April.
Third April. Third April.
Well,
Have a case.
Okay. Mr. B. Sharma learned additional PP shall produce the case diary before this court on that day.
Only one thing, my lord, only one thing at page 25 my lord, in my bill application. The learned CGM specifically stated that. Stated that the materials into the case record and the case that it appears that the accused person, Sri Rajiv Kulita, no, not that. Continue, Baba. Not a case of hideous. It is an attempt of extortion in state of offense of extortion. So there is no case of extortion, my lord. Attempt is not a extortion. That is on that point, my lord, bail allowed by the other two accused. By
Let
the-
the city come, we will.
my lord,
Yes, my.
Tablet.
May I please, your lordship? Here is a case, my lord. The petitioner had remained absent from duties from 1/11/93 to 14/9/94. Thereafter, the DI has placed the petitioner under suspension from 15/9/94. And the petitioner has been reinstated in service after direction passed by this honorable court in setting aside the suspension order, that the petitioner was reinstated in service. That is annexure 1051. That's just the repetition of on that other day we have already gone through this. Page 51, annexure 10. Annexure 10. In compliance of the order.
Page 51 is annexure 8.
No, sorry, man. Then your lordship kindly take the matter WBC number 4026/23. It will cover the all earlier cases also.
So how many WPC are pending?
Two, my lord.
Two.
Only two. Because subsequently I have been dismissed from service. So this petition has come up again.
page 51.
So earlier petition or what happened to earlier petition?
Is pending like that, my lord.
Yes. Page number.
51 and except 10. In compliance of the Honorable High Court order dated so and so, as in WBC number so and so, Tucker Ete versus State of Assam and others, and in pursuance of government letter number so and so, Chief Tucker Ete, who was placed under suspension by the then DI of schools, Junai, by so and so, the dated 5994, is hereby reinstated with immediate effect. Then subsequently by addendum, that is annexure 11, page 52. That while reinstating the petition in service, second paragraph, my lord, it is further added that as per FR 54B, 1A and B, the pay and allowances after reinstatement is to be paid to Sri Takar Ete, assistant teacher of so-and-so school, at the rate just before placing it under suspension. Now, on the other day also, we have seen that FR 54B, 1A and B meant for the period spent during suspension shall be treated as a regular service. That's what this section says. 54(1)(a) and B speaks about the period spent on suspension shall be treated as a period spent on duty. Whatever may be, my lord, they have the pay scale of the petitioner has been confirmed in this by this rule. And subsequently, my lord, 3 SOCOS notice has been issued for initiating the departmental proceeding against me. Those 3 departmental proceeding are, that is page 53, annexure 12. On the same article of charge. While the one is the while you were working as assistant teacher at Rigby Government LP School, you were remained absent in the school from 1/11/1993 to 14/9/94.
Mr. Sinha,
Yes.
earlier DP was drawn up against.
Yes, the DP was drawn up against by this, my lord. Thereafter, DP was, my lord, no,
After his suspension, DP was drawn up against.
no. This is the first time. First time when he was reinstated in service, the petitioner. Then only the DP has been drawn. This is the first time, first SOCOS notice has been issued.
So
That is
annexure 12 is the
first
SOCOS notice.
first SOCOS notice. This is the initiation of DP, my lord.
Okay.
Before that, not DP, my lord.
When he was suspended?
Suspended on 15/9/94.
15/9/94.
And suspension order also he did not receive. He received only after submission of the order of the Honorable Court on suspension order. Yes. Suspension order, your lordship will find page 43. So this suspension order petitioner has received on 12/12/2018, when the order of the Honorable Court was communicated. Then only he received the suspension order.
12/12/2018.
Para 12 is the statement I have made. Para 12 is the statement. Then I'm the first SOCOS notice, the article of charge was that I was remain absent. Yeah. So I think we will go to SOCOS notice, man.
On 12/12/2018, they
18.
have received the
Suspension order.
And when they have revoked the suspension order?
Suspension order, that is annexure just 10 mile by 13/8/2020, page 51.
13/8/2018, suspension
No,
order was
13/8/2020.
20.
Yes, ma'am.
suspension order was revoked.
Yeah, I have been reinstated. By this order, I have been reinstated in service. Yes, by next order, that is addendum. Addendum,
DP has been started against you.
no, before that, the period of suspension, actually, they have regularized my service of service that period, my lord. That will come later then, my lord. Then now DP was initiated.
No, okay, you come this page number 52. That is
Yes.
annexer
Yes,
11.
52 FR, 54 B, 1A and B, the pay and allowances after reinstatement is to be paid. They have said this one. But FR 54 B, 1 says, FR 54 B, 1 said, whether or not 54 B plus 1, then subclause A and B. May I read, my lord?
Yes.
Yes. When a government servant who has been suspended is reinstated or would have been so reinstated, but for his retirement on superannuation while under suspension, the authority competent to order reinstatement shall consider and make a specific order regarding the pay and allowances to be paid to the government servant for a period of suspension ending with reinstatement or the date of his reinstatement on superannuation, as the case may be. And B, whether or not the said period shall be treated as a period spent on duty. Said period shall be treated as a period spent on duty. Now, my lord.
So what was the order in your case?
Order, this is the case 52. They have considered only the pay and allowances, and other, they did not mention anything. But by operation of law of 54(1)B, the period spent on should be period, the suspension period should be spent on duty. So that's why, my lord, we have filed the earlier writ petition to regularize the period of suspension and all. And now, while pending on this, the many things have happened that I will come later, my lord. Or I may take your lordship to that writ petition now. The order I have annexed here, that page 74. What the order passed by this honorable court in that writ petition for the regulation, suspension period and salary and allowances to be fixed. In that writ petition, the honorable court has passed page 74, and operating part your lordship will get from page 78. From clause 5, it's a para 5. It is an admitted fact that the petitioner has not been paid his subsistence allowance during the entire period of suspension. The question as to whether the petitioner would be entitled to relief as stated in the writ petition would be decided at a subsequent stage, but the entitlement of the petitioner for the subsistence allowance for the period from so and so cannot be put to question in view of categorical findings in the inquiry report. Then, pending disposal of the instant writ petition, this court, therefore, for the ends of justice, direct the respondent authorities to pay the subsistence allowance to the petitioner for the period from 15/9/94 to 13/8/20 within a period of 45 days. My lord.
So you have been paid?
No, I have been dismissed from service by this DP. they have now hurriedly completed the DP letter. In spite of complying these, they have hurriedly, that DP what the SOCOS notice has been issued, they have hurriedly completed and dismissed me from service. Wait. Yes, I'll come. My lord, when the requisition is there, how IA by dismissing it, they have said they have dismissed. Now we may go to SOCOS notice then, now. So contempt also we have filed for this.
Page number?
Page number 59. No, 50. First SOCOS notice 53.
Okay, after your reinstatement in service,
Yes.
you have discharged your duty.
Yes, I have joined in duties. Even
You
I have
received
been
your salary.
Yes, that is money. In some months I have received, some months I did not receive. Even I have been allowed to hold the charge of headmaster also. And thereafter I have retired from service on 30/4/2022. After retirement. Now there is also a question whether DP may continue after retirement. That is also a question, man. After retirement, whether DP
You have retired on
30th April, no? 30th April 2022.
2022.
Yeah. Now this first initiation of DP is page 53 on 13/8/2020 is the first SOCOS notice. The article of charges are that I have remained absent without any authority, and I have also not complied with the SOCOS during that period while I was absent. Issued, I did not reply.
So after retirement, they have drawn up the certificate.
DP before retirement.
Before retirement.
Before this 13/8/2020.
Okay.
Now, whether it can be continued after retirement, yes, they may continue, but law is different. Before retirement, DP has drawn. And after retirement, DP completed and I am dismissed from service.
What is that order?
Yes, that order, your lordship will find page 80. That's I have already retired. May I read, madam? Peruse the Honorable High Court order dated 5/6/2020 passed in so-and-so Tucker at so-and-so, wherein Honorable Court had observed that as the very appointment of the petitioner is under question, this court is of the view that it is an aspect which can be decided by the authorities in accordance with the law. Also read the inquiry report in connection with departmental proceeding drawn up against Tucker at a retired assistant teacher of Rigby Government High School under Dhemaji district as submitted by District Elementary Education Officer Dhemaji by her letter number so-and-so dated 1/4/23 along with statement of allegation of charges formulated under the said departmental proceeding and the reply of Sri Tucker Ate to SOCOS notice. Number 2, the statement submitted by the petitioner Sri Tucker Ate at the time of hearing in the office of the Director of Elementary Education Assam dated 22/6/2020 and SOCOS reply dated before the DEO Dhemaji dated 3/17/2020. This also we may objection is there because this hearing 22/6/2020 no DP was initiated before that. No hearing. So Deputy Director, it was I have already this annexed the letter. That is, deputy director has taken the hearing of suspension case, not the DP. So they cannot bring the record of that suspension case in the DP. They can bring, but by giving copy to me. Then 3, the letters is based, letter issued to the petitioner by this office order number so and number so and so, dated 3/5/2023 for submission of written reply against the finding in the inquiry report submitted by the DEO Dhamaji, so and so, so and so. Number 4, the acknowledgement of this office letter number so and so, so and so, so and so, showing received by Sri Takar Ete on 25/4/2023 and 10/5/2023. Now this is, your lordship may note it, my lord. 10/5/2023, on this day, I have been communicated with the inquiry report. 10/5/23. Giving me 3 days time. 10/5/23. Then 3, government letter issued number so 26/7 so and so. Findings. In the SOCOS notice, 2 specific charges were levied against the Tucker at the inquiry officer, that is Deputy Inspector of School Junai, and presenting officer BEO Murkoksaleng had conducted the inquiry fairly and in accordance with the principle of natural justice. I do not know where is justice. I do not know the inquiry is processed. No notice or the date of inquiry, whether fixed or not, that also I do not know.
You have not participated?
No. How can man? Because they did not issue anything. That on the so and so day, inquiry is fixed, you have to appear before the inquiry officer. Nothing I have received. Nothing I have received. No date of inquiry, they cannot show any order that so and so issued, you are directed to appear in the inquiry. Or I have to put my defense. I was not allowed to put my, because I do not know inquiry, they have own expert inquiry. It is like an expert inquiry. Yes. Second paragraph. The inquiry officer found all charges formulated against Sri Tucker Ete as established beyond any doubt. It is seen from the.
Where is that inquiry report?
Yes, inquiry report is there. I have an inquiry report.
Page number?
Yes, page number is 66. That I have remained absent. Then I did not submit any record. All those things are there in the inquiry report. When it was prepared, there also I do not know how it is prepared. I do not know, my lord. I have not appeared before the inquiry. Things are that I have remained absent in duties from 1/11/93 to 14/9/94. Then I have been placed under suspension. All these things are there in the inquiry report. Now, whether I have been served, there is a, when I have placed under suspension, there is a SOCOS notice they have said that it was issued. In spite of saying that, they have said that it was served on me. I have remained absent in the school till 14/9/94. On SOCOS notice, how they could be issued a SOCOS notice, why I have remained absent. For that, I have been placed under suspension. That SOCOS notice is never served upon me. I have not received at any point because I was absent. I was at home. I was sick. So now let us come to again that impugn order, my lord. Or shall I go through the inquiry report, man? Inquiry
No,
report.
there's impugn order.
Yes, impugn order. Then the inquiry officer found all the charges of so and so, so and so, so and so beyond doubt. It is seen from inquiry report that Tucker at a so and so school remained absent in school from duty with effect from 1/11/1993 to 14/9/94 at his own will, and even he had not felt the necessity for submission of any application seeking leave of absence to the school authority or any immediate higher authority. This is also reflected in the proceeding of executive meeting of SMC Let's go my seven paragraph. You are therefore requested to appear in hearing on 22/6/2020, positively at 11 a.m. in the office chamber of undersigned, along with concerned Deputy Inspector of School with supporting documents on the matter, and also requested to communicate the petitioner to instruct Tucker at the assistant teacher of so-and-so school in the hearing with supporting documents on that day positively. Now, your lordship may look into this. Letter was issued on 15/6/2020. Before issuing of DP, this hearing held on 22/6/2020 before issuing of DP by the deputy director, who is not the disciplinary authority. By the DP, before DP was initiated on 13/8/2020. First DP was initiated. Prior to that, in the case of suspension case and writ petition, I was heard. Okay, this record or whatever hearing statement I have stated before that, this record, if to be accepted in the inquiry, I was required to furnish the documents, or it should be placed before the inquiry. But no document was placed before the inquiry because inquiry was not held. Same as the case.
No, Mr. Sinha.
Yes.
Who filed this WPC 2352 of 2019? You?
Yes, I have filed.
What happened to that?
Their directed suspension order was set aside by this court.
By that order?
Yes. Suspension order was set aside. Then only I have been reinstated in service. Pursuant to that,
And thereafter, this
DP has been DP has been initiated from 13/8/2020. Prior to that, it was not DP. Then your lordship will find, letter go, my lord. From the above, it is revealed that both the statements of Tokarate is contradictory in nature, and he has tried to misguide the authority. Further, it is seen that Tokarate has retired from service on attaining the age of superannuation on 3/04/2022. However, the departmental proceeding was initiated against Tokarate during the period of service, and the same has been continued after his retirement, and as such departmental proceeding initiated against Tokarate is deemed to be a proceeding under Rule 21 of Assam Services Pension Rules 1969. This is very important, man, this one. Now, after retirement, the departmental proceeding has continued. So now departmental proceeding will continue. The law is that this rule will apply now. Now, not the disciplinary rule will apply. This Assam Services disciplinary appeal rules apply, man. Now, whatever may be, I will come later. Then order has been passed. In view of the above, it is concluded that petitioner Sri Tokarate, retired assistant teacher of Rigby Government LP School, has failed to give any explanation against the finding of inquiry. He was found absent without leave, permission, or authority from his duty so and without informing the school authority or any immediate higher authority. The petitioner Sri Tokarate never approached before the authority from the date of suspension up to 2015. Even he never approached the higher authority for his suspension allowance during the suspension period by submitting application along with non-engagement certificate effort so and so. Sri Tokarate has also tried to misguide the authority by submitting contradictory statement before two different higher authorities, once at the time of hearing and previously while submitting his so-called reply. Hence, the undersigned finds that Sri Tokarate has committed acts of serious misconduct by remaining absent without leave or authority, and moreover, upon being given opportunity to explain his conduct, he has tried to misguide the authorities. Keeping in view this misconduct committed by Sri Tokarate, assistant teacher so and so, he is hereby dismissed from service as per Rule 7 of the Assam Service Disciplinary Appeal Rules. The period of his suspension, the period of this unauthorized absence from duty 1/11/93 to till the date he was placed in a suspension shall be treated as dice non. The period spent, my lord, this is very, my lord, dice non, my lord. The period spent under suspension of Sri Tokarate shall be treated as such. He will not be entitled for any suspension allowance during his suspension period, in absence of any claim that he was not otherwise engaged during that period. Again, the language again says, that he was not otherwise engaged during that period. I have retired. I have also allowed to hold the charge of headmaster also. How can they again say this one? If he was not otherwise engaged during the, I have been reinstated in service. Now,
No,
here,
during suspension period.
yeah. Okay, my lord. Now, my lord, this impugn order has come. I have been, I was supplied with the inquiry report on 10/5/2023, giving me 3 days time. Now, General Clauses Act also says 3 days time. 1, 2, 3 will count from 16. Sorry, 11. Then 2 days time will be 12. Then 3 days time will be on 13. But on 12, the impugn order has been passed. Now, whether dismissal for service will apply in my case. Now, they have himself says, Rule 21 of the Assam Service Pension Rule 1969. After retirement, this rule will be enforced. Now, pension rule. Pension code, my lord, we may look into the Rule 21.
Pension rule.
Yes, Rule 21. This rule will govern my punishment, not the disciplinary appeal rules. Because I have retired from service. Pension rule. Yeah, the pension, Assam Services Pension Rules, 1960. Rule 21.
Yes.
Yes. The governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery from a pension of the whole or part of any pecuniary loss caused to the government, if in a department or judicial proceeding, the pensioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered upon re-employment after retirement, provided that such departmental proceeding clauses, if instituted while the officer was in service, whether before his retirement or during his re-employment, shall after the final retirement of the officer be deemed to be a proceeding under this rule, and shall be continued and concluded by the authority by which it was commenced in the same manner as if officer had continued in service. Now, this rule applies. This rule does not speaks about any dismissal from service. Now, they have himself admitted the Rule 21, then disciplinary proceeding may be continued. Now, punishment, whether punishment again they go to the disciplinary rule, no. This rule will apply. I have the disciplinary proceeding under this rule and shall be continued and concluded by the authority by which it was commenced in the same manner as if the officer has continued in service, as if I am continued in service till the day of ending of proceeding, as if I am deemed to be in service, and the punishment would be there is no mention about the punishment. Only departmental findings they may arrive at. Now, by passing the impugn order,
Yes.
now by passing the impugn order, the respondent have, my lord, the direction which I have read in the other petition. That is page 78. It was passed on 13/3/2023.
Other writ petition.
Yes, the earlier writ petition that I have annexed the order also here.
Page number.
Page 75 and relevant part is page 78. That pending disposal, para 6, pending disposal of the instant writ petition, this court therefore, for the ends of justice, direct the respondent authorities to pay the sufficient allowance to the petitioner for the period from 15/9/94 to 13/8/2020 within a period of 45 days. Now, by impugned order, they have overruled the order of this honorable court. They did not comply, rather says that it should be treated as a dice note, whereas then did not go on appeal against this order or review, that their respondent did not file any review application or any appeal against the order passed by this honorable court. So I was bound to file this petition again after having got the dismissal order. But whether it is possible for the respondents to overrule the order of the High Court and to come at the finding that should be treated as dice note. Period of suspension, who is the honorable court directed to pay the substance allowance. They say that no, it is treated as in the subsequently without reviewing this order. This order is still operating till today. Now,
No, Mr. Sinha,
yes,
this court has directed to pay them the subsistence allowance within the period of 45 days.
yes,
I ordered it at 13/3/2023,
yes,
right?
yes, ma'am.
So as per rule, are you not supposed to file that during that period? You are not
Yes,
facing any other.
yes, we have filed.
You have filed?
Yes, we have filed.
Okay.
We have filed.
Okay.
We have filed.
But then it import.
We have filed. We have filed.
After retirement, they are filed. Non-engagement.
Yes, because they have raised the question. They have raised that the court has allowed us. Court has allowed us, yes, whatever it is you file in that earlier petition, it is there. Order after night. Now, the inquiry report submitted to me by letter dated now, your lordship may come to page 64. They hurriedly completed the inquiry and submitted the report.
Page 64 of which
This requisition, what we are, my lord.
earlier.
No, present requisition.
Present. Page number 60?
64.
64. Yes.
Yes. Here, my lord, they have communicated the inquiry report, which I did not receive at that time. That's why subsequently again they have issued another letter. Now, be that as it may, my lord, your lordship, second paragraph, you are hereby directed once again to submit your written reply within 3 days of receipt of this letter. 3/5/2023. They have communicated me the inquiry report. You are hereby directed once again to submit your written reply within 3 days of receipt of this letter to the undersigned against the findings of the inquiry report, damage is so and so, so and so.
So this letter was issued to you on 3rd of May.
The 3rd of May they have issued, but they have communicated me on 10/5. Communicated me on 10/5. In the impugned order, it is mentioned. In the impugned order as page 80, third line from the bottom. Page 80.
No, you have already shown it.
Yes.
It was communicated on 10/5.
10/5/2003, giving me 3 days time.
And when the impugned order was passed?
12th May. Within 2 days. Not even, just after 1 day. That is on the 2nd day.
Yes.
Now, let us go to that second writ petition, my lord. That first writ petition. Now, while that writ petition was pending, they have filed a miscase, IA. I am not law.
What is the number?
Number is 1658.
1658 is a WBC number.
A WPC number.
Is it 728? Okay.
Now, in that repetition, sorry, in this IA, they have come up with the modification of order of this, that which this honorable court has passed on 13/3/2023. That would
Regarding
make
that
payment of
subsistence
subsistence allowance. They have come for modification of this order. That stating that he has been dismissed from service by the impugn order. Whether it is a rule of law that in spite of dismissing, they may come up, but before dismissing, they first to obtain the leave of the court. Without taking any leave of the court, after dismissing me from service,
So what order was passed in this IA?
I no order, no order, no order.
Oh.
It has been marked with the writ petition. It has been marked with the writ petition for final hearing. So they have come with the IA there that we cannot comply with the order of this honorable court because we have dismissed his service from, we have dismissed him from service. Wait. Yeah.
No, Mr. Soma, please. First, let him complete.
So they have come. This court by order dated 13/3 2023 to comply with the order of this court within a 45 days. Even time also the honorable court has framed. Within 45 days, they are to pay the subsistence allowance, and about the service or suspension, whatever it is, this court has specifically said that it will be decided on the later stage of the hearing of that writ petition. Now, 45 days has passed, they did not comply. They did not comply 45 days, that they have come later on in the year 2024. That we have dismissed him from service on 12, that by this impugn order on 12/5/2023. So he is not entitled to obtain the subsistence allowance. Whereas this order was passed on 13/3/2023. The dismissal has come up on 12/5/2023. Whether can it be done?
Mr. Sharma, the record of departmental proceeding is available with you.
Proceeding record is not there, Lordship. Your proceeding record is not there, but the notices and everything. One point I just would like to point out.
No, I'm just asking.
Lordship, otherwise records are here.
Records are.
Records are here. I went through it and I will press it before Lordship.
Yes, Mr. Sinha.
Yeah, so my thing is that, my lord, DP has initiated on 13/8/2020. Prior to that, whatever hearing taken place was in connection with writ petition, which we have filed earlier, because contempt was also filed before that for non-compliance, for reinstatement me in service. Now, I have also allowed to hold the charge of headmaster also. Later on, I have retired. Now, after retirement, DP has continued. So after retirement, DP would be continued on the basis of that Rule 21 of Assam Services Pension Rule. Now DP has no role to play thereafter. Now on that, again DP.
What would happen under this Assam Service Pension Rule?
Yes, that rule will apply. On that, whatever the power is there, the departmental authority shall have to do, or whatever.
What is the power for the department?
Power, nothing is there. Only to make an inquiry after that, because now disciplinary rule they cannot apply. This is a bar. Disciplinary was because there is it is specifically mentioned. It will be continued as if the delinquent is in service. Such departmental proceeding, if instituted while the officer was in service, whether before his retirement or during his re-employment, shall after final return of the officer be deemed to be a proceeding under this rule. Under this rule, it deemed to be a proceeding.
What is provided in this rule?
Nothing, because later on the other proviso are not applicable to me. It is proviso applicable to in other cases But for me, they have come with a dismissal. The Rule 21 never speaks about the dismissal from service. Never speaks about for dismissal. Other provisions are there, but those are not applicable to me. Let him say if it is applicable to me. Now, there is a deemed to be a proceeding under this rule. So now entire this proceeding, DP, whatever initiated, converted to now under this rule. So in the DP, my lord, they are clubbing together, my lord. Clubbing the administrative order also, clubbing with the DP. The DP is a quasi judicial proceeding, my lord, DP. Now they have the special power, the disciplinary authority has the special power to act upon it. Now discipline, who is the disciplinary authority here? Their first SOCOS notice was issued by DI. Second, District Elementary Education Officer. Third, Director of Elementary Education Officer. On the same article of charges, 3 SOCOS notice has been issued. Now, who is the disciplinary authority? Now, after that, appointment of inquiry officer and presenting officer has to be there. There is no order to show or no order to communicate with me that so-and-so date has been fixed, inquiry officer is so-and-so, presenting officer is so-and-so. Now, while DI was going with the SOCOS notice, he has also submitted an inquiry report. That this inquiry report and later subsequent inquiry report are different. Now, I will come to that. Now, page 53 of secondary petition. That SOCOS notice was issued by Director of Elementary Education Assam, that 13/8/2020. I have replied to that.
Page number?
Page number 53. This was issued by Director of Elementary Education Assam. I have replied to it. Then page 56, second SOCOS notice again by DIF school.
Page number?
Page number 56. Now I have replied to it. Then you will also find inquiry report submitted to DIF school by the.
So this is the SOCOS notice issued by the DI.
DI.
And where is the letter of DO? District Elementary Education Officer.
Yes, I will come later. I will come later. Yes, subsequently district education. Now here, DI, what he has done, he has obtained an inquiry report, expertise from Block Elementary Education Officer. Page 58. This is the inquiry report, my lord. Regarding submission of inquiry report into the matter of allegation against it occur at a so-and-so, your letter under reference number 29/3/21. This is one of the inquiry report. Whatever, I don't know how inquiry report was prepared, how made, no notice was issued for hearing. Now, third inquiry report, so third inquiry, DP, SOCOS notice, page 59 by DI, sorry, District Elementary Education Officer. Now punishment has been imposed by the impugn order by the Director of Elementary Education.
Director relied upon which inquiry report?
That is, that is also, my lord. Your lordship may look into that. Look into, my. That is again another inquiry report prepared, page 66. Page 66 is the inquiry report. Your lordship will the last page 69 of the inquiry report. Here I found that inquiry officer is DI of school. In the sign manner, sign SD eligible inquiry officer DI of school Junai. Then the left side, block elementary education officer, Mukox as a presenting officer. Then let them show where is the notice that inquiry officer and presenting officer was appointed. When it was they were appointed and what was the date fixed for the inquiry. Then we may go to, my lord, now prior to application of this pension rule 21 to the disciplinary proceeding rule, my lord. We may go there, my lord. Disciplinary appeal rules. Discipline and appeal rules. Mal, the rule 9 maybe kindly look into, my rule 9 when DP was initiated.
No, take minute. So is it in the educational matter?
No, my lord.
There is
Assam
separate-
Services Disciplinary Appeal Rules. By this rule, they have initiated the DP against me. Rule 9 may we look into, man. May I read, man?
Rule?
Rule 9.
Yes.
The SOCOS notices were issued under this rule. Now, clause 2 of Rule 9, the disciplinary authority shall frame definite charges on the basis of allegation on which the inquiry is proposed to be held. Such charges, together with the statement of allegation on which they are based, shall be communicated in writing to the government servant, and he shall be required to submit with such a time as may be specified by the disciplinary authority a written statement of his defense, and also to state whether he desires to be heard in person. At the time of delivering of charges, the disciplinary authority shall invariably furnish to the government servant a list of documents and witnesses by which each article of charges is proposed to be
So
sustained.
in your case, who is the disciplinary authority?
Yeah, that is also, but ultimately punishment has been imposed by Director of Elementary Education. The DI of school has also issued SOCOS notice. Then District Elementary Education Officer also issued SOCOS notice. And ultimately in the inquiry report, what I found, DI of school is the inquiry officer and block elementary education as a presenting officer. Now, totally beyond the rules, against the rule. Now, your lordship will find where by order, by which order I have been placed to put my defense in the inquiry. Where is the order? I do not know. Subsequently, they have collected all the records and they have gone through the records that I have done so and so, and passed the interim order. It is a proceeding. No, it is not a proceeding. I have been provided with all opportunity, whatever the rule says. Even your lordship will find the DP, that SOCOS notice does not have list of witnesses and does not have list of documents. Nothing has been mentioned. Simply the charges are there.
In one of the so-called notice, they have given the article of charges.
Yeah, and statement of allegation. But no list of witnesses and documents. DIF school has given, sorry, Director of Elementary has given statement of allegation, but no list of witness and list of documents. Now, without furnishing those, can they produce or can they produce in the inquiry those documents? Page 53. Yes. Where is the list of witness and documents? Taken allegation is there. List of witness, list of documents not there. If any extra document or whatever documents they are to take up in the proceeding, they have to furnish me the copy. That these are, we are going to furnish, we are prove the cases against you. Where is those? Just like our judicial proceeding in the court, my lord. They have to take it. Then your lordship will come, my lord. Clause 3. Say same, the government servant. Clause 3. The government servant shall, for the purpose of preparing his defense, be permitted to inspect and take extracts from such official records as he may specify, provided that such permission may be refused if for reasons to be recorded.
Mr. Sinha,
Yes.
you are referring to which document that list of witnesses and
No, nothing. No, because no inquiry initiated. No inquiry, sorry, commenced. Though inquiry initiated, but inquiry process of inquiry was not commenced. Then only had one I will come to know that so and so that they are going against me, so I have to make my defense. Where is those? Completely, Rule 9 has been completely violated. Directly, suddenly, when the order passed by this honorable court to make payment of subsistence allowance, then directly, hurriedly, they have completed departmental inquiry. All these are not permitted under Rule 9. Not permitted under rule. Every step they are to take me under notice that we are going to do so and so against you. In every step. Clause 6. This is also a proceeding just like our court, man. Our whatever the court below, we try our cases. They're exactly the same, or little different. Now, clause 6. The inquiry authority shall, in course of the inquiry, consider such documentary evidence. Clause 6. The inquiry authority shall, in course of inquiry, consider such documentary evidence and take such oral evidence as may be relevant or material in regard to the charges. The government servant shall be entitled to cross-examine witnesses, examine in support of charges, and to give evidence, and to produce documentary and oral evidence. Now, before that, clause 5. Disciplinary authority may nominate any person to present the case in support of charges before the authority, inquiring into the charges. The government servant may present his case with the assistance of any government servant approved by the disciplinary authority, but not engaged by practitioners for the purpose.
so Mr. Sinha, you show me the
Manal, they never informed me that inquiry is processed.
Show cause notice of DI.
Yes.
DI show cause notice in page number.
DI Sokos notice page number 56.
Page number 56. DI 56.
Then District Elementary Education Officer Dhamaji is at page 59. Now I'll take your lordship. After issuing this Sokos notices,
And the show cause notice issued by the director.
yeah, director is page 53.
Page 53. Yes.
Now I will come to the page 62 now, my lord. After issuing Sokos notice, now this letter has issued by the director to the government. What shall be done in the case? Man, here your lordship will find page 62. If we go through, sir, with reference to the subject cited above, I would like to state that in pursuance of government letter number so and so is enclosed. The DEO Dhemaji, District Elementary Agent Dhemaji, was instructed to submit the draft charges and statement of allegation against Sri Takarate. And accordingly, District Elementary Education Officer Dhemaji has submitted a report by letter number so and so, dated so and so, along with Sokos reply of Sri Takarate of so and so school. After receipt of the report from DEO Dhemaji, a directorate level committee is constituted. I don't know from whose power or authority they have constituted this one by the director. A directorate level committee is constituted by order number so and so. And accordingly, the inquiry committee has submitted report to the undersigned regarding regularization of suspension period of Sri Takarate. Now, subsequent paragraph, it is to mention here that the inquiry committee has suggested in the inquiry report that the period of unauthorized absence with effect from so and so to so and so in respect of Sri Takarate may be treated as no work, no pay under Rule 71 of FRSR. And on the other hand, for regularization of period of suspension with effect from 15/9/94 to 13/8/2020, views of Judicial Department, Government of Assam may be obtained as he was not allowed sufficient allowance during the period of suspension by the then DIS, Junai, and as it involves huge amount of financial implication to be incurred from the government exchequer. Then in this regard, the inquiry report regarding regulation of services of teacher so and so under Dhemaji is enclosed herewith and request the government to take necessary action. Now, what shall we mean by this, my lord? This letter is what? Is an inquiry, or he is taking information, collecting information from the government, or he himself is creating a committee and taking the suggestion of that?
No, we are not
Yes,
actually
madam.
on this letter.
Yes, madam.
We are concerned with
Yes,
the
yes, yes.
departmental
But the
enquiry, how
departmental
it
enquiry.
was
So
conducted.
we are not concerned with this order.
Okay.
So now, after having this author, there is a Rule 9 also says that I have been allowed to put my defense.
No, that's all right.
Yes.
Now the question is whether that Rule 9 is complied with or not.
Not complied.
During
And later on, I have retired. Later on, I have retired. So after retirement, now Rule 21 will apply. Now, whatever gone earlier. Now, later on, the section 7 of rule disciplinary appeal rules, they cannot go for it. The rule 7 of this Assam Services Disciplinary Appeal rules, where punishment are described. My lord, that rule cannot be applied now because they have now changed. The thing has been changed after my retirement. So entire earlier proceeding after, as per Assam Services Disciplinary Appeal rules will now go by the rule of Assam Services Pension rules. This is the law, my lord. Now, if we go, then order, fundamental rule 54B, 1A and B says the period spent on duty is a period under spent on duty. That they himself says by issuing addendum. Now, one aspect of the matter also is that this honorable court in earlier writ petition, why the petition has filed it, because during the course of that writ petition, they have produced the dismissal order. Surprisingly, my lord, without doing any review, they have come with a modification of the order after dismissal. Now, this honorable court has treated that my suspension errors may be paid, but they say that no, he has been dismissed from service, so he cannot be paid. Can it be done? So,
Well, I resume after 5 minutes.
yes, ma'am. Apply.
So while conducting the disciplinary proceeding, this rule 9 has not been complied with by the authority.
Yes, yes, ma'am.
So your part is over.
Yes, my part is over. Rule 9 has not been followed, and it will totally, my lord, go by to the rule 9, and suddenly they have commenced the inquiry and hurriedly completed same, that also under rule 21 of pension rules, where no punishment is referred of rule 7 of disciplinary proceeding. I may give reply to him, let him continue. My part is over.
Lordship, here we have received record also, Lordship. So before placing the record, Lordship, may point out, in so far as the payment of subsistence allowance is concerned, Lordship, there was a direction of this honorable court. But FR 53, if my Lordship may kindly, there is the FR 53, 2, 53-2. Which provides no payment under sub rule 1 shall be made unless the government servant furnishes a certificate that the government servant is not engaged in any other employment, business, profession or vocation. So under FR 53-2, Lordship, he has to furnish non-engagement certificate. During the course of service, he never furnished that no non-engagement certificate, Lordship. Now, Lordship, may kindly see. The petitioner, Lordship, may kindly see the conduct of the petitioner.
Whether you have informed him to furnish the certificate.
Lordship, that we have already issued so cause notice before initiating the departmental proceeding, which my learned friend had placed before the Lordship.
No, after the order being passed by this court for granting him the subsistence allowance.
Lordship, may kindly take up my
order
IA.
was produced before the court.
Yes, Lordship. Yes, Lordship, may kindly peruse my IA, Lordship.
No, in IA, no order was passed in fact.
No, there is subsequent development also. Now, Lordship, may kindly take up that IA first.
So after dismissal of service, you have filed the IA.
After
to circumvent the order of this court in granting this
subsistence allowance. On the ground that no non-engagement certificate whatsoever was furnished by the
No, my
petitioner.
question is whether you have informed him to submit the certificate.
Lordship, may kindly peruse my this interlocutory application, Lordship, because the matter again came up before this court. Again came up before this court, and we submitted before this court that because of the non-engagement of the that direction is further there. My learned friend has surpassed that. He did not bring it before this Lordship. Page number 9 of my IA. that the applicant begs to state that the petitioner did not pay for grant of subsistence allowance at any point of time from 5/9/1994 to 13/8/2020 by producing his non-engagement certificate under
No,
FR.
no, that's all right. That is not here his case. But
Lordship.
after the order of this court, what you did?
Now subsequently, Lordship. Paragraph number 4, it is stated here. That from the record, it is seen that the departmental proceeding initiated against the petitioner has been concluded by issuing order dated 12/5/2023, whereby this petitioner was dismissed from service under Rule 7 of the Assam so and so so and so. In the said order, that the period of his unauthorized absence from 1/11/1993 till date, he was placed under suspension shall be treated as diagnosed. Further, the period spent under suspension by the petitioner shall be treated as such, and he will not be paid entitled for any substance allowance during the period of suspension period in the absence of any claim that he was not otherwise engaged during the period. In the said order dated 12/5/2023, it was observed that the petitioner did not furnish any application along with non-engagement certificate under provision FR so and so for grant of substance allowance. The said writ petition came up for consideration on 15/5/2023, on which date the order of dismissal dated 12/5/2023 was placed before the Honorable Court. Upon perusal of the order dated so and so, the Honorable Court observed that due to non-furnishing of the non-engagement certificate, which is required in terms of so and so, the subsistence allowance was not paid to the petitioner. This Honorable Court, by order dated 15/5/2023, directed the department to bring on record the order dated 12/5/2023 along with the stand of the department. Since the order dated 13/3/2023, a specific direction was issued to pay the subsistence allowance to the petitioner within a period of 45 days. So that order dated 12/5/2023, it has been placed. Otherwise, also my learned friend has agitated that. Therefore, Lordship, now Lordship, the petitioner remained absent from 1993.
That's all right. That is, he also not disputed it.
And during the tenure, he never approached the authority. My learned friend has submitted that he did not receive any show cause. So I will produce the record which will speak for itself. Now, 13/8/2020, he was reinstated in service. On the same day, the departmental proceeding was initiated on 13/8/2020. He was dismissed on service from 12/5/2023 on 12/5/2023. But he retired on 13/8/2020. Non-engagement certificate, Lordship, he furnished after his dismissal, 23/6/2023.
No, you have not answered my question.
Lordship.
My question is,
Lordship.
after the order being passed by this court for granting him the subsistence allowance,
Lordship.
did you inform him that he has to furnish this non-engagement certificate?
Lordship, he was represented by his friend, his counsel,
No.
Lordship.
My question is, did you inform him that there is a requirement for furnishing such a certificate?
The time and again, Lordship, that particular instruction, I will obtain instruction. Otherwise, time and again, and otherwise also.
No. From the record, you tell me whether you have informed him.
In so far as the payment of subsistence allowance is concerned, I have not come across that later. But Lordship, may I produce this record? Place it before your Lordship.
That's all right, you will produce it.
Lordship.
Okay.
That
So there is
particular.
there is no letter in your record to indicate that
Lordship.
after the order being passed by this court for granting subsistence allowance,
Lordship.
you have not informed him in writing that you are required to submit this certificate, non-engagement certificate.
That letter I have not come across.
Okay.
Lordship. Moreover, Lordship, the petitioner was represented by my friend before this court.
No, I am not
So,
asking that.
Lordship. And there was a direction by the order dated 15/5/2023 to furnish that. And during that period, entire period, he never
There was a direction to
produced that non-engagement certificate.
when?
By the order, Lordship may kindly peruse the order dated 15/5/2023 of this honorable court.
Fifteen?
15/5/2023.
In which matter, IA or in
In,
petition?
the matters were clubbed 1658 of 2022.
One?
1658 of 2022.
Okay.
We have apprised this honorable court that no non-engagement certificate were produced.
Thirteen, five,
15/5/2023, Lordship.
23.
23.
Again.
Merely because he has been he has been dismissed from the service later on.
Lordship.
Can you deny this subsistence allowance to him?
Lordship, not merely on the basis of the dismissal, but Lordship, the FIR 53 provides
Right, but
non-engagement certificate
action
has to be
you have taken.
has to be
But,
furnished.
that question is, can you deny in the subsistence allowance?
No, Lordship, merely on dismissal, we cannot deny. But Lordship, whether that is provided in 53 to Lordship, that non-engagement certificate has necessarily been furnished. That has not furnished earlier. And secondly,
No, when it was furnished?
it was furnished on 23/6/2023.
23/6/23.
2023. He was dismissed on 12/5/2023. And they have placed before this honorable court judgment of the division bench of this court, Lordship, for
Dismiss on?
dismissed on Lordship 12/5/2023.
So you could not comply with the order of this court.
Lordship.
But is it the justified ground for denying him the subsistence allowance?
No, Lordship. Because he was subsequently dismissed. And after dismissal, and now, Lordship, that is why, Lordship, I want to place before your Honorable Court this judgment of the division bench. For recovery of arrear, there is a limitation. So, arrear salary service law provides for recovery of any arrear salary, claim has to be made before 3 years. There is a division bench judgment is also there. In Harendra Chandranath. Claim for area, whatever area salary or any due from the authority, there is a time limitation. He remained suspended from 1994 and till 2020, he never claimed subsistence allowance. He never furnished non-engagement certificate. No right available to recover arrear beyond 3 years. This judgment provides, Lordship. This is a division bench judgment of this Honorable Court.
Recovery by the
By the employee, whatever he wants to claim.
So whether this division bench judgment is concerned with
For
the
claim of
departmental
any
proceeding.
claim of any salary or arrear, Lordship. So the heading
sir,
itself provides
no,
service law recovery of arrear limitation held no right available to recover arrear beyond 3 years from the date of filing of the writ petition. So that is there, Lordship.
Sir, Sharma,
Lordship.
as far as I know, there is a decision of Supreme Court
Lordship.
where it is stated that right to this subsistence allowance is
Lordship,
a
Lordship,
fundamental right.
Lordship, that is their Lordship. Now, Lordship.
Then how this decision will help you?
Now, Lordship, may I place the record also, Lordship? And then Lordship will see the conduct of the petitioner during the entire course of his service.
No, one by one. First, this subsistence allowance. So you have not issued any notice to him.
That I have not come as yet,
Okay.
Lordship. Let me.
There was a direction of this court dated 15/5/2023
Lordship.
to furnish the certificate.
Lordship.
Then he had furnished the certificate on 23rd of June 2023.
23rd of June 2020.
But you have not acted upon the same since you have dismissed him on 12/5/2023.
Lordship.
Okay.
Now, Lordship, may I place the record? 175. It will be there. Now, this is Lordship, page number 175. This is the reinstatement order. This reinstatement order is of prospective effect, Lordship. Page number 175. Now, on the very same day, the departmental proceeding has been initiated. Lordship may find the departmental first show cause on page number 176 with the statement of allegation. Page number 176.
Hmm.
176. Now there is some. So 176 is the show cause reply. 181 is the show cause reply. 181. But insofar as the pagination is concerned, lordship, some here and there is there also.
So government records are always like this.
Page number one eight
So
one.
this is the so-called reply.
Reply.
So where is the statement of allegation?
Lordship, along with the so-called notice, lordship, one,
And
page
list
number
of witnesses?
176, 176.
Okay, and list of witnesses?
List of witnesses, lordship. that,
Not furnished.
Perhaps, no, I cannot say lordship.
No, not perhaps.
It is
your
not there.
record. You
It
definitely
is
tell
not
it,
there.
tell me whether it was furnished or not.
I have not come across that list of witnesses.
Always diplomatic answer.
Perhaps lordship. Because
You tell me, is it there or not?
it is not there. It is not
Okay.
there. List of witness. Statement of allegation is there also. Page number 181 is the so-called reply.
So-called reply, yes.
Lordship. Now, another so-called was issued on 23/3/2021, which is on page number 201.
Page number 201.
201, Lordship. And reply to that second so-called Lordship is page number 207.
Page number 207
Well,
is
Lordship
the
is the
reply.
reply.
Yes.
And now my learned friend was putting a question mark whether the inquiry committee was constituted or not. Your Lordship may kindly peruse page number 215, the constitution of the inquiry committee.
215.
215.
Okay. Two, 1, 5.
And Lordship, page number 214 is the inquiry report.
214.
And 212 is the reply by the petitioner. Reply dated 1/7/2021, which proves that he participated in the inquiry. Page number 212. Now, on the basis
No,
of this,
no, Mr. Soma,
Lordship,
is disciplinary authority has appointed the DI.
Lord,
or school
DI officer was
and block elementary
education officer, marking select,
Counseling
or
as enquiry officer
and presenting officer.
And this memo is updated 38/6/21,
Lordship,
right?
Lordship. 1/7/2021, Lordship, this inquiry report. of 21, page number 214, Lordship.
Page number 214.
4,
214 is the inquiry report.
Lordship.
So you have completed inquiry on one day.
No, Lordship. That report was, in fact, was appraisal letter to the director. Otherwise, that inquiry report is here, Lordship. My learned friend has annexed with the writ petition.
No, you show it from your department, on
Lots
a
of-
departmental record.
Lordship, that I will find out, Lordship. And Lordship, thereafter, on the basis of that district level inquiry, Lordship,
No, whether you have examined any witness.
that
No.
proceeding is not there, Lordship.
So then we no need to hurt you.
Lordship. Because the proceeding record is not there, Lordship. That is the difference. However,
So by this order dated 30/6/2021, inquiry officer and discipline this presenting officer was appointed.
Lordship, they furnished a report where
And page number 214 is the report. And when you have examined the witnesses, then whether
Lordship,
you have given notice to him.
Lordship, I will just check once that record, as so far as the inquiry report is concerned, Lordship, may kindly keep it in for the timing, Lordship. And subsequent development, I will apprise, and thereafter I will. Lordship, on the basis of the report of the district level committee, Lordship, another committee was constituted in the director level, Lordship.
Whether such a committee is contemplated in the disciplinary and appeal rule? No. Where do you got the authority?
That with the approval of the government, with the approval of the government.
From where the government derived the authority?
Lordship.
Government have to derive it either from the rule or from the act.
Lordship.
Admittedly, no such act and rules are there. Okay. So you please go through the record.
Lordship.
You advise me.
Lordship. And Lordship, so far as the.
So we'll hear you again at 2 o'clock. In the meantime, you go to the record.
Lordship.
We'll take up some other matters now.
Lordship.
Mr. Sinha will resume at 2 o'clock.
Yes, ma'am. Right.
Maybe, this last minute it was listed for Lordship on 12th, and your Lordship directed to produce the original select list. Original select minute dated minute 27/10/1999. That is the direction of yours.
Yes, Mr. Soma, you received the select list.
Lordship, I received the select list just now. Lordship, my fix that I have not gone through. Just now, the officers from the department came and furnished it to me.
Okay.
That list is, they have furnished the list. So Lordship may fix after 1 week, Lordship, let me go through and I will pass it before Lordship.
Okay, then let him go to the record.
Just today itself, I just.
Heard Mr. Rosid, learned counsel for the petitioner. Mr. Sarma, learned standing counsel for the elementary education department, submits that he has thus received the record from the department concerned. And he prays for granting him 1 week time to go to the same. There is allowed recess and list the matter on 7th of April as parted.
Lordship. Much of that.
May I please, Your Lordship?
Yes.
Look, in terms of last order, Lordship, I have brought on record that particular order, whereby the order which is under challenge in the petition has been set aside. Your Lordship has gone through that. That has already been recorded in the last order.
Lordship, I haven't been served a copy of the affidavit, your lordship.
কি স্যার তো কইছে বাজু কিন্তু আপনার অবশ্য তাহলে একটু বেলেগ কথা মই দি আছো আপনার কাছে অর্ডারটা দিছিল না কিন্তু অর্ডার আর বেলেগ তো ইয়াতে নাই না ইয়াতে বেলেগ এখন খেলাই নহয় খালি এইটো ৰেকৰ্ড কৰিম এটা কথা বেছি বেছি দিব লাগে
Professor Khan, you have filed the additional affidavit.
My lord,
When?
we have filed it that is on record lordship. We have filed it on 3/3/2025.
Okay.
Lordship, it start from lordship page 73.
Page
73.
73.
And that order lordship is page 76. The first order that is challenging this writ petition, that is your lordship will find page 51. In that order, lordship, they have rejected my claim for pay protection in one ground, page 51.
Yes.
And
And they have granted pay protection to another person.
yes, that has been
Page
given.
number?
Yes, page lordship, page 49.
Page 49.
My lord. He was on under the same umbrella. He was deficit under deficit college.
Abiruddin Ahmed.
My lord. He has been granted. And now lordship by the order which is annexed in the additional affidavit, they have taken another ground, and this order which is under challenge, letter which is under challenge in the writ petition has been set aside, which is absolutely lordship against the lordship is contrary to the law laid down in the division bench that has already been recorded in the last order. Your lordship.
Now, what is your prayer?
My lord, my prayer is that the priority should be lordship given because this person lordship, similarly situated person, he has been given. And so for the ground taken subsequent ground, that is also not in a lordship. And the in view of the lordship, another decision that I can rely that the ground taken in the impugn order should be relied upon, and no additional ground can be taken by way of additional filing an affidavit. Or-
That Maninder Singh Gill case.
Lordship, that is, yes. That is in Kopil Nodi Matsyajivi Samabhay Samiti Limited Lordship. And in the
That is
Supreme-
of this,
in
this
Supreme-
court.
yes, and Supreme Court is Maninder Singh, yes, Lordship. Maninder Singh Gill. So that new ground Lordship cannot be taken by way of filing an.
What is the new ground?
New ground, they are taking that the application ought to be filed within 1 month. That is during the pendency of the disposition, this order has been filed.
No. What is the ground they have taken?
They have taken that the application was not filed within 1 month in view of the Lordship provision of FR Lordship. And in the first letter Lordship, they have taken a ground that I was served under deficit system of grants in a college.
My lord, may kindly come to page number 77, your lordship, of the affidavit filed by the learned petitioner, your lordship.
So where the 1 month time is prescribed?
Yes, Lordship, that is in the provision is, yeah, Lordship, I have. Well, their petitioner could not submit the application on time because at that time, Lordship, his earlier period, Lordship, was not regularized. And that period was regularized, Lordship, only in the year of 2018. And he was, Lordship, initially, Lordship, he was removed from service in the year 2011. That was challenged before this honorable court. And the honorable division bench, Lordship, has interfered with the order. And he has been, Lordship, given the pensionary benefit.
So where it is provided this 1 month time?
Yes, Lordship. Lordship, FR 22-1. I have given that relevant part, Lordship. May I read? The initial pay of government servant who is appointed to a post on time scale of pay is regulated as follows. Where a government servant holding a post other than a tenure post in a substantive or temporary or officiating capacity is promoted or appointed in a substantive, temporary or officiating capacity, as the case may be, subject to fulfillment of the eligibility condition as prescribed in the relevant recruitment rules, to another post carrying duties and responsibility.
No. Where it is provided this 1 month time limit?
On the second page, your lordship.
Second page. Second page, which part?
On the page 38 in the book, your lordship, in the book, page 38.
So you are referring to the book.
Yes, your lord.
Well, in the second paragraph in that. Save in cases of appointment on deputation.
Yes.
To an ex-cadre post or to a post on ad hoc basis or on direct recruitment basis, the government servant shall have the option to be exercised within 1 month from the date of promotion or appointment, as the case may be, to have the pay fixed under this rule from the date of such promotion or appointment, or to have the pay fixed initially at the next sale in the level of the post to who is he or she is promoted on regular basis, and subsequently on the date of accrual of next increment in the level of the post from which the government servant is promoted. His pay shall be refixed and two increment account of annual increment, and the second accrued on account of promotion shall be granted in the level from which the government servant is promoted, and he or she shall be placed at a sale equal to the figure so arrived in the level of the post to which he or she is promoted. And if no such sale is available in the level to which he or she is promoted, he or she shall be placed at the next higher sale in that level. So that 1 month time lordship that has been prescribed in this room. My lord, reply to that lordship, stand lordship we have given in my reply affidavit lordship.
Page number
Yes, lordship, 68.
60.
68.
Okay.
But with regard to statement made in paragraph 7 of the affidavit, it is stated that
Paragraph number
paragraph 4, lordship.
4. Yes.
It is stated that although the petitioner was appointed on 5/7/1990 as inspector of school, this is the promotional post, lordship. This is a direct recruitment post to another post. After relieving the post of lecturer in philosophy of Shivsagar College, he did not file his application seeking pay protection immediately after the date of his subsequent appointment as the past service as lecturer with effect from 14/11/1983 to 16/7/1990 was not counted along with the period of service rendered under 3F of the Assam Service Commission regulation with effect from 17/7/1990 to 9/8/1998 as inspector of school for pension and pensioner benefit. In the meantime, the petitioner was dismissed from service by an order dated so and so by initiating departmental proceeding. Thereafter, petitioner filed WBC number so and so dismissed on so and so. Thereafter, an appeal being WBC number was filed, which was allowed by an order dated so and so, whereby dismissal order of the petitioners modified to compulsory retirement with consequential benefits, however, without back wages. Accordingly, the said order has been complied with by an order dated 4/1/2017. The petitioner thereafter filed his representation dated 21/9/2017. This is the representation lordship claiming regularization of that service period as well as the pay protection with a prayer for counting of past service with pay protection. Thereafter, the joint secretary to the government of Assam issued a letter dated so and so, whereby the past service of the petitioner with effect from so and so as lecturer of Shivsagar College along with the period of service rendered under 3F regulation with so and so as inspector of school has been counted for the purpose of pension and pensionary benefits subject to refund of government share of CPF amount which he availed during his service period at Shivsagar. Accordingly, the petitioner has refunded CPF amount and thereafter by an order dated 7/8/2018, the aforesaid period of past service has been counted for the purpose of pension and pensionary benefit without, however, pay protection. Thereafter, the petitioner submitted another petition so and so lordship. The government thereafter by a letter dated 15/11/2020 expressed the inability to consider his proposal towards counting of past service pay protection as the period from so and so 14/7/1983 to 16/7/1990, the petitioner served as lecturer in deficit college. The petitioner filed another prayer on so and so, pointing out that his one of the colleague Kubruddin Ahmed has been allowed by government for pay protection.
No need to read out.
Why not? Since my service lordship was
You have two contention.
my lord.
One is you have been discriminated by not granting the benefit, while the same was granted to one of your colleague.
My lord, number one.
Then the other is they have rejected your prayer on the ground that you have not filed the application within 1 month.
That is a subsequent one, which is
Subsequent.
which is
That is
not
not in the order.
yes. And so far, the first the ground taken in the first rejection, that is, I was served under deficit college, so I am not entitled for pay protection. Case 51, which is under challenge in this petition. The lordship is aware that prior to 2005, there was no provision for provincialization service of the college employees. This is for the first time lordship college service provincialization act was enacted in the year 2005. Prior to that, all colleges under deficit college, and they were lordship given the UGC scale of pay by the government. So only difference is the Act 2005 as well as the prior to that deficit college, that now the college employees will get pension. And earlier there was no such provision. So deficit college, only because of deficit college I was served. prior to appointment in the inspector of school or deputy director of school. That ground is not sustainable. The Kobiruddin Ahmed, he was also on the same, in the same college. That was under deficit college. That was pay, everything was given by the government. So that ground, that's why Lordship, subsequently they have taken another ground that he has not filed this application within 1 month. So earlier stand he has rejected, and subsequently another ground he has taken. And that, Lordship, to that effect, Lordship, I have replied to that, that why the petitioner could not, Lordship, file the application within 1 month. Yes, Lordship, the order, the service period which has been regularized, that is, your Lordship will find at page 72. This is the order of 2018. This is the government order, Lordship. I am directed to say that so and so department have agreed to count the
Page number
page 72.
72, annexer 1.
Annexer 1, Lordship.
Okay.
In my reply affidavit.
Yes.
With reference to the above, I am directed to say that P and PG department have agreed to count the past service rendered by Anwar Hussain, retired district elementary education officer, Kasar, with effect from 14/11/1983 to 16/7/1990 as lecturer of Shivsagar College, along with the period of service rendered under 3F of APHC regulation with effect from 17/7/1990 to 9/8/1998 as inspector of school for his pension and pensioner benefit, subject to refund of government share of CPF amount which he availed during his service period in Shivsagar College. Therefore, you are requested to let this department know whether Anwar Hussain has refunded the share of CPF amount available by him or not. If he has, copy of treasury. And that subsequently I have refunded that amount that is in the petition. Lordship, I have annexed that.
Page number.
Lordship. Yes, Lordship. Page 43, Lordship. In inviting a reference to the correspondence quoted above, I am directed to say that Governor of Assam is pleased to count the past service rendered by Anwar Hussain with effect from so and so as lecturer Shivsagar, along with the period of service rendered so and so with effect so and so. He has already refunded the government share of CPF amount of rupees so and so. Only that he had availed during his service period at Shivsagar College. A copy of treasury allowance so and so is given. So my past service, Lordship, after that, my past service has been taken into account. Thereafter, Lordship, we have filed this petition. This petition was, Lordship, for counting of past service as well as for pay protection. They have counted the past service, but without considering the pay protection.
So, as per this letter, at page number 51, your past service has been counted.
No, past service, Lordship, that is page
51.
No.
Annexer 18.
Yes, that is the, Lordship, my prayer for pay protection has been rejected. And so for past service, Lordship, that is, I have relied with Lordship that I have annexed along with the my reply affidavit as well as page 43. So that is no issue on that. My past service has already been counted. I have refunded that amount.
Yes, 72.
My lord.
Your past service has been counted.
My lord.
But this pay
That was
protection has not been given.
subject to payment of CPF amount that I have given, that is page 43. So that part, Lordship, there is no issue on that. Now, Lordship, issue is only relating to pay protection. That has been rejected, that is page 51. As per division bench order lordship, the subsequent order that is non-est, that will be non-est in law. That is not enforceable. Because during the pendency of this repetition lordship, they cannot sit over the matter.
Where is that?
Lordship. Para 50. Two thousand 14, 4 GLR, para 15. Give it, 4 GLR, 3. Para 15 loss. Regarding changing of stand lordship, I am relying that judgment lordship.
Changing of?
Stand taken in the.
Yes, madam, we will hear you after break. Yes.
My lord, your lordships have already heard the matter at length. This is something.
Only there was no contention raised. Madam Ginny has already said that if we reduce the sentence, she is having no objection. But there was no submission from your end to
My
that.
lord, I can understand.
So we wanted a detailed submission so that we can also consider.
I have limited submission because I'd like to rely on a judgment of Supreme Court.
Other submissions we will consider. But if we go against you in that, then what?
My lord, it's 2009-15 SCC 635. My colleague only told me last evening that it will come for hearing. So I was not very prepared, well prepared.
Why only last evening, not in talking terms?
But in paragraph 23, some factors have been asked to be considered while awarding appropriate sentence to the accused. And the very first relevant factor is the motive or previous animosity. Now, if we take the victim statement for a while, he himself, victim, page 43, victim's deposition, he in the second line on oath, he says that I have no enmity with him, with the accused person. So there was no motive at all in this case, present case. And in the judgment, the 23H, the nature and size of weapon used for inflicting the injury, the force with which the blow was inflicted. That has to also be considered. Then criminal background and adverse history of the accused, whether the injury inflicted was not sufficient in the ordinary course of nature or cause of death, but the death was because of shock. Number of other criminal cases pending against the accused, incident occurred within the family members, so and the conduct and behavior of the accused after the incident, whether the accused had taken the injured, the disease to the hospital immediately to ensure that he or she gets proper medical treatment. So these are the factors which it needs to be considered while deciding the sentence, quantum of sentence. But as far as first motive and animosity, the victim himself said that there is no enmity with them between him and the accused person. So that may be considered. And regarding the position of the Khaja Bandhu, well, if Arms Act in section 27, 25 1BA, it says whoever acquires has in his possession or carries any firearm or any ammunition in contravention of section 3. So the punishment will be imprisonment for a term which shall not be less than 2 years, but which may extend to 5 years, and shall also be liable to fine, and shall be leviable to fine. This is the first one, and the other provision, section 27, 27(1) of the charge. It says punishment for using arms, etc. Whoever uses any arms or ammunition in contravention of section 5 shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend to 7 years, and shall also be liable to fine. So the maximum punishment
7 years.
7 years. Not less than 3 years, but which may extend to 7 years. And there it's not less than 2 years, maximum 5 years. In the present case, the under trial prisoner, he has already next day, no? Since 2020, December 2020, he is inside behind the bars.
More than 4 years.
More than 4 years. My lord, my humble submission, considering these factors, that there is no motive, there is no animosity between the accused and the victim, and for this punishment under the Arms Act, this is not a fit case where life imprisonment has to be granted. There is no motive at all.
No, some sort of motive can be attributed to his conduct. Because one witness was examined.
Yes.
She picked the wife of the accused.
But she has
stated something.
hostile. She was.
Motive can be attributed to him.
That is true. She was declared hostile.
She was declared hostile, of course.
Hostile.
But that statement was proved by the IO.
Yes. There, I indicated on last occasion, there are some lacunas on the part of the counsel for who was conducting the trial.
Yes.
And we also relied upon one judgment of the Supreme Court. That's the at least
Yes.
this is a 10 years experience. So there was no cross-examination, nothing. So there are some lacunas in conducting the trial. That Ashok versus State of UP's judgment.
That judgment you have already.
I have already,
covered,
yes, yes. And in that case, the person accused, the person got acquitted. That's my limited submission.
Mr. Tado.
Yes, Your Worship. My learned friend has referred the depositions of victim, page 43. Here he says, clearly says, pointed out that after shooting him, he ran away, not toward him to help. If there was no any such motive, there was no such any enmity. He ran away. He was almost dead if nobody comes in time. And now he is living with a paralyzed conditions, cannot do any work and all. It is more punish. It is more serious offense than committing murder, because in 302 it's one-time elimination, but he has to bear this pain for all the life. And Your Lordship, yes, 225, 25 and 27 Arms Act, there is a lesser punishment. But 307 and 326, for there, he deserves to be punished with the same as a learned trial court has awarded, life sentence, Your Lordship. And it may be upheld as in total. That's all, Your Lordship.
Okay. Yes, madam, for the victim.
Amicus.
Your Honor, I've already made my last submission on my last occasion online.
No, on the point of this sentence.
For the sentencing, Your Lordships.
Yes.
I am in the same footing as the PP has stated.
Okay. Okay.
Yes,
Heard Mr. Edward, learned for the appellant. Mr. Tado, learned for the respondent part. And madam, your good name, please.
SV Daram.
For the respondent on part 2. The argument concluded. Judgment result.
My
No, I think I read it. Yes, madam.
Lordship, it has clearly said in Annexer 76, Your Lordship.
Annexer?
70, Annexer 176 of the affidavit, Your Lordship. Page 76, why his representation has been rejected, Your Lordship.
Yes.
Main paragraph is in page number 77, Your Lordship. After due consideration of all the materials on record, it is found that Mohammed Hussain has claimed pay protection under the provisions of FR 9 within bracket 23, FR 22, 181 of the FR 37. Your Lordship. It is seen that FR 22, 131 deals with options of fixation of initial pay. The purpose and per the rule is to be able by the government servant within 1 month of appointment, Your Lordship. Mohammed Anwar Hussain has first raised the issue of pay fixations after much delay only in 2017, Your Lordship. Further, no explanation has been provided for the
But
delay in
madam,
claiming
tell
such.
me
Lordship,
whether in view of the decision of division bench of this court in the case of Akkada Saleh versus Tito Bazar, reported in 2014 for DLR 3. Can this order, impugn order, sustain?
Let's start a federal proceedings on the very same subject matter.
So, Mr. Khan, you have relied upon which paragraph?
Paragraph 15, Lordship.
Paragraph 15, Your Lordship.
15.
1-5.
So representation should be filed within the period of 1 month, Your Lordship, but here in his part, there has been a delay.
That's all right, but in the earlier order, that stand was not taken by you.
Which order, Your Lordship?
Yes, 50.
Which is the letter by which your pair was rejected?
Case 51, Lordship.
51.
My lord.
So the subsequent ground taken in your affidavit and also in its order. So not there. Then if we can ignore this order dated 24/11/2024 in view of that decision. Have you gone through that decision? It's Akkada Saleh,
Yes.
paragraph number 15.
Yes, Your Lordship.
So in view of that decision, this order has a non-instant law, high of law. This order, which was passed subsequently by after filing of this writ petition, 24/11/2020.
In,
But in any case, Malad, his entitlement will be decided under the FR and SR, Malad. In FR and SR, Malad, he is not entitled. As per 22(1)(a)(1), Malad, he is not entitled. While deciding the earlier round, Malad, it was not considered, the FR 22. But subsequently, while in subsequent decision, Malad, it was considered and it was found that, Malad, he is not entitled.
That's all right, but the question is, you cannot improve your case by your pleading by subsequent
This is not an improvement, Malad. This is an entitlement decided under the law, whether he is entitled under the law or not, Malad. Because his right to get a pay protection is defined under FR, my lord. In FR, he has to claim within one month, but he has claimed after his retirement, my lord. So under the law, he is not entitled. In any case, my lord, if he wants to challenge this is a fresh cause of action. He can challenge it, my lord. But there is no bar to decide the issue under the law, my lord. We are not improve upon the facts, my lord. Whatever is there, my lord. Because first, while deciding the issue, my lord, that this FR was not considered. Now, the department considered his entitlement under the.
No, in view of that decision of Supreme Court in Managers Aid,
Yes, my lord.
you cannot improve your case by filing your additional affidavit or like.
Yes, my lord, that I understand, my lord. We are not improving on facts, my lord. Whatever is there. But can this court, this honorable can ignore this law, my lord, FR 22, while deciding the entitlement of the petitioner, my lord?
So we are to go by the pleading. We are to go by the impugned order.
Yes, my lord. In here, my lord, in the subsequent order, whatever is there, we have decided on the basis of the FR 22(1)(a)(1). His earlier claim, earlier it was rejected that the college was deficit. College was a deficit, that is why he is
But
not
in
entitled.
case of another candidate, the relief was granted.
Yes,
He was also serving in deficit college.
That is why, my lord. That is why, my lord. Case was serving in deficit college, but that time this FR was not considered. The FR 22 was not considered, my lord. Can you see the order, my lord? Page 49. No?
That's all right. That was not considered.
But subsequently, the department, while deciding the issue, the entitlement of the petitioner has to be decided under the law. Then law FR 22 clearly speaks that he has to approach the authority within a month. But he has approached after his retirement. He joined in the year 1989. And after his retirement, now he is claiming, my lord.
Okay. Any other point?
No, my lord. This is the only point. We are relying on the FR 22, my lord.
Hard district का करना है तो थोड़ा you for higher education department.
No, my lord. I'm second reason.
Secondary education. I don't know. Also for higher education.
My lord may record the name of each MP, my lord, because C basically C.
Learning spectacles for the respondent number 120. Argument concluded, judgment is there.
Much problem.
I think item number 20.
No. Item number 20.
That inquiry report, Lordship. Lordship is- Inquiry report, Lordship will find at page number 249.
Of your file.
Lordship, this record. 249. It was not concluded on 1/7, Lordship. It was concluded on 31/3/2023. And Lordship will find at page, that inquiry report, 249. DI of School Hoja is the inquiry officer and BEO Mukang Selak is the presenting
Inquiry officer.
presenting officer.
This inquiry was conducted by DI of school.
DIF school as an inquiry officer. And BO Markhum Select.
So
as-
since when to when this inquiry was conducted?
This inquiry was concluded on 31/3/2023. Your lordship will find a statement.
2023.
Lordship, your lordship will find.
And when it was started?
It was it was constituted in 36/2021. And lordship, at page number 250, your lordship will find the statement of the petitioner.
Page number?
Page number 250. There is a two-line statement, lordship,
250.
regarding his non. Page number 250. I'm sorry, lordship, 240. Along with that, 249 is the inquiry report. 240 is the statement of the petitioner during the course of that inquiry. And now, lordship, this inquiry report has been furnished to the petitioner. Wide
During this inquiry, no witness has been examined.
As such, lordship examined. There are witnesses that DIF school and some other officials were inquired. That your lordship will find from 249 onward.
49 onward.
Lordship, there were
Statement of witnesses.
witnesses and some officers, block elementary education officers, and some records were also produced. 249 onward, your lordship will find.
It starts from page number?
Page number 249, lordship. That is the inquiry report, and subsequent
49
pages,
is the inquiry report.
lordship. And
Statement of witnesses.
thereafter, lordship.
Page number.
Subsequently, 248 to 240.
240.
240 is the statement of the petitioner, and 241 to 248, some other investigation materials are there. Some documents were seized by the some officials that were.
Tell me whether accept or examine.
No, as such, witnesses were not. No. And lordship, this inquiry report was furnished to the petitioner by communication dated 24/4/2023, which has been duly acknowledged by the petitioner.
Page number.
Your lordship will find at page number 254.
254.
Lordship. There is a signature of the petitioner. That first so-called notice, which has been duly acknowledged, received by the signature is there in the letter, which was furnished on 24/4/2023. He did not reply to that. Therefore, the second letter dated 3/5/2023. Where also
Page number.
page number 255. Here also petitioner has duly acknowledged. Hence, the termination order dated 12/5/2023, lordship.
The question is whether the petitioner had participated in the departmental proceedings brought up against.
That lordship, that 240 page number 240, the statement of the petitioner, one-line statement, and that inquiry report also verifies that he participated. If the lordship will kindly peruse that inquiry report at page number 249. There is a statement. There is a statement of the petitioner, lordship. After article charge 2, the Sri Takar Ete has stated in his statement that he was unknown about any so-called notices served to him, and no so-called notice was received by him. Therefore, the question of dishonor of submission of so-called notice does not arise. This was the statement, which proves that he participated in the inquiry committee, lordship. Now, Lordship, insofar as the show cause notice is concerned, Lordship, he has different statement in different dates. So, Lordship may kindly. In page number 212, regarding that suspension letter, what he has stated in different dates. In page number 212, if your Lordship kindly peruse, he claims that he has received suspension order. Page number 212. Even on 240 also he has accepted to have received. He refused to have received. Page number 212. He claimed to have received suspension order. And page number 240, he refused to have received. So his statement is contradicted in both the occasions. And insofar as the statement, his statement is also concerned about his unauthorized absence, Lordship. If your Lordship kindly peruse page number 222, he says, due to illness, he could not inform the authority. Page number 220. He says that due to illness, he could not inform the authority about his unauthorized absence. On the other hand, I will also peruse page number 220. He says that due to illness, he could not inform. Now, on the other hand, as page number 168, if your Lordship peruse, during the hearing, Lordship, 168. Due to communication problem, he could not inform. Page number 168. So there are contradictory statements from the petitioner regarding his unauthorized absence. Page number 168. He says that due to communication problem, he could not inform the authority. He has never informed the authority. He remained unauthorized absence for such a long time. And again, page number 212, before Lordship peruse, the show cause reply, he says, due to illness, he could not inform the authority. So, as such, he has not come with the clean hand, Lordship. He remained unauthorized absence for such a long period. Admittedly, there are certain technical deficiency on the part of the respondent department that I do not deny. But Lordship may kindly consider the conduct of the petitioner. One remain unauthorized absence for such a long period, even he does not appear before the authority claiming his subsistence allowance during the tenure. After retirement, he furnishes his non-engagement certificate. Once a person retires, Lordship, he remains unengaged, Lordship. But what about those periods?
You take whatever step you like, but in accordance with law,
Lordship.
not in contrary the provision.
Lordship.
This inquiry was conducted in violation to the provision of Rule 9.
Insofar as Lordship, that list of witnesses are concerned. Otherwise, statement of and list of otherwise statement of allegations.
Yes, Mr. Sinha, any reply?
The reply is that list of witness and list of documents. Documents where to be inquiry report, your Lordship will find. Is original copies, Xerox copy 70. Inquiry report, there is no date. Inquiry report also, there is no date. And statement, whatever he says, statement, I have been asked to appear before the Deputy Director of Education, Deputy Director in the administrative capacity, not in the DP capacity. Because I have been, by letter dated 15/6/2020, Annexure 9, where I have directed District Elementary Education Officer, directed by the Deputy Director of Elementary to appear on 22/6/2020. There I have been made some statement, but that is not DP. That is, my lord, Annexures 9. That is by letter dated 15/6/20. I was called for along with the District Elementary Education Officer. And subsequently also I was called for. So those are not in the capacity of DP. Deputy Director is calling me and he is taking statement. Who is he? He is neither inquiry officer, not presenting officer, nor disciplinary authority, Deputy Director. Now their statement, perhaps those I think record will say, those under what notice or what letter I have appeared or made a statement. That will clear the fact, because I do not know whatever they are in the record. But so far I know that Deputy Director has called me in the hearing in connection of WPC, writ petition, or earlier writ petition. That cannot be the part of DP.
That is a different inquiry, Lordship. That is pertaining to his application for regulation of service. That is a different inquiry level, conducted by at the director level for regulation of his salary, not regulation of his service, not for the departmental proceeding. Departmental proceeding, your Lordship may kindly peruse that page number 250, where he has addressed to the DI of the school, not the deputy director of the school. And Lordship, one more point, Lordship, in regard to that Rule 21 of Pension Service Rule, that clarifies that once a departmental proceeding is initiated during the course of his service, that can be continued after his retirement also. That clarifies. It is not that once that is applicable, so that disciplinary and appeal rules is not applicable. That is not there. Lordship, this clarifies, Rule 21 clarifies that once the departmental proceeding is initiated against an incumbent during the course of his hearing, that can be continued after his retirement. That clarification is there, Lordship. It is not. I'm sorry. If your Lordship kindly peruse that Rule 21, the Governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering to the recover from pension of the whole or part of any pecuniary loss caused to the government. If a departmental proceeding or judicial proceeding, the petitioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered upon re-employment after the retirement, provided that such a departmental proceeding, if instituted while the officer was in service, whether before his retirement or during his re-employment, shall after the final retirement of the officer be deemed to be proceeding.
Yes.
Under this rule, shall be continued and concluded by the authority by which it was commenced. So it was commenced under disciplinary appeal rules.
Yes, that thereafter.
And Lordship, in the same manner, as if the officer had continued in service. Explanation is also there. Lordship, may kindly peruse the explanation. The continuation of proceeding after the final retirement of the officer shall be automatic under sub-rule A of Rule 21. No fresh decision of the government, of the governor and of the appointing authority, nor any so-called notice to the person concerned shall be necessary, because it has already been initiated. The power under Rule 21 shall be exercisable not only in case of causing pecuniary loss to the government, but also for on all other cases. So here it is clarifies that can be continued. It is not that once.
No, can continue that there is no dispute about it, but can you impose such a punishment of dismissal after he retired?
Lordship, that is because the Lordship may kindly consider, appreciate Lordship, conduct of the petitioner, Lordship. Now, he remain on, Lordship, may I submit, Lordship, 2 points, Lordship. He remain a government servant, a responsible teacher, remain unauthorized absence from 1/1993 till 30/8/2020.
No.
He was placed under suspension on 1994, but he never turned up even for the subsistence allowance also. He has never turned up before the authority, nor he informed about his unauthorized absence, and contradictory statement in different occasions. Sometimes he says due to communication problem. Sometimes he says my illness was
Okay. So, you cannot commit conclusively that whether the punishment of dismissal can be imposed upon a person who has already returned.
There is no bar, Lordship. There is
No
no
bar.
bar. Can punish.
Yes, third, the Sinha, third and fourth court of opinion. And Mr. M.P. Sharma,
PN Sharma, Lordship.
E.N. Sharma, third and counsel for the respondent for the
Always.
Lordship, may kindly note that communication of 24, 24/4/2023, the first occurs whereby the inquiry report was furnished to the petitioner and he duly acknowledged.
Lord, it is there. Thank you. Lord, just first petition was for fixing my salary and all. Fixing my salary and all, first petition was filed. While pending that petition, I have been dismissed, so second petition has come. Only that is the thing. Oblige.
you also take up Mr. Sharma has furnished the relevant file of the department. They be kept on record.
Lord.
The same shall be part of it.
Oblige.
Supplementary, section number 27. Lordship will keep the record, Lordship.
Beverly. But here in this matter, my lord, the petitioners total 25 numbers. They are grade 4 employees of the my lord, MA school and MA madrasas of Dhobi district, pertaining to Dhobi district. Here the case is, my lord, in 1991.
Whether the affidavit was filed?
No, no affidavit has been filed. In fact, my lord, here it is a case, my lord, where even the government also took decision from time to time for granting retrospective benefit for to the my lord, grade 4 employees, including the present petitioners.
Mr. Sharma, where is your affidavit in this petition?
27 April.
In fact, on the last occasion, the department informed us that a copy of the writ petition was not furnished to them. I have already communicated on Lordship that writ petition was also communicated to the department previously. So Lordship may fix 2 weeks time, Lordship. After 2 weeks, I will obtain instruction. Here the communication has been made. On the last occasion, they informed us that a copy of the writ petition was not there with the department. So we furnished it, Lordship. 2 weeks time, Lordship.
No issue, my lord. Otherwise, my lord, the issue is very simple, my lord. Here, my lord, what we are claiming, my lord, we are claiming that in 1991, my lord, in very short, my lord, I am narrating my.
Today, in fact, I don't have the brief also.
No issue. Only within 1 minute, I'll make it. In 1991, my lord, total 1255 number of schools were provincialized. MA school, my lord. MA school, including MA madrasa. Out of 1255, 500 schools were provincialized in the first phase. In that first phase, teaching and non-teaching posts both were regularized. Now, after 1 year, 755 number of schools were provincialized in the second phase. But in the second phase, only teaching posts were provincialized, but the non-teaching posts were not provincialized. Now, after 5 years, again, the government directed the director to create the remaining 755 number of left out posts of grade 4 with effect from the same date, the previous date, my lord, from which, my lord, the teaching post of those 755 number of schools were provincialized, my lord. But the director, my lord, while creating the post were created from 1996 itself, not from 1991, my lord. From the first phase, the benefit which was granted to the first phase grade 4 employee, as well as to the teaching post also, which were my lord, sanctioned, created in 1992, my lord, after 1 year. Now, the government is also, my lord, taking decision from time to time to grant a retrospective benefit to those 755 number of grade 4 employees.
Subsequently, your service has been provincial.
My lord?
Subsequently, your service was provincial.
Provincialized in 1996.
1990.
96, after 5 years. But the government directed that this
those left out 755 number of schools grade 4 also be created from the previous date, my lord. The benefit should be given from the previous date. But in fact, that benefit has not been given to us, my lord. Now, since the government is there, government took the decisions from time to time to grant the retrospective benefit to the left out grade 4 employee, including the petitioners, and the benefit has not yet been paid till date, my lord. So only the implementation of the decision is required, my lord. There is no dispute. The government is not disputing that we are not entitled. This is the decision of the government that we are entitled. We are entitled for the retrospective benefit, but that decision should be implemented, my lord.
Where is the decision?
My lord. Annexure, first, my lord, I'll take your lordship to Annexure 3, my lord, for a moment. Lordship may kindly come to page number, the first annexure, page 17, my lord. Here I will show, my lord. This is the provincialization order in respect of one of the schools in the first page, my lord. The first page.
No, that's all right. But you tell me,
my lord,
where is the decision to grant the retrospective benefit?
My lord. That decision, my lord, that decision, my lord, page number 88, annexure 5, my lord. From Deputy Secretary to the Government of Assam, issued to Director of Elementary Education Assam and Director of Education BTC, my lord, regarding retrospective benefit of provincialization to the grade 4 employees.
Yes.
In the subject, my lord, I am directed to say that the matter has been examined by this department by taking it out with the Finance Department, and accordingly, you are requested to furnish the following information in consolidated manner as per the pro forma given below, district wise. Now, this is the pro forma. This next page. This may please be treated as most urgent and ensure submission of recorded information within 15 days from the date of receipt of this letter for further needful action from this in. Further, you are requested to examine the matter whether the required fund will be available under appropriate head of account during the current financial year. Now, page number 91, and it's a 6, my lord. This is the, my lord, proposal submission. It was submitted to the Commissioner and Secretary Government of Assam by the director. This is the proposal. Submission of the proposal regarding retrospective benefit of provincialization of grade 4 employee. This is the, my lord, proposal, district wise proposal, my lord. Because, my lord, throughout the state of Assam, my lord, all the district elementary education officers and deputy commissioners, my lord, they were directed to furnish the particulars of their districts to the direct.
No, you showed me the letter by which the government has agreed to pay the retrospective benefit.
Then, my lord, page number 93 also, my lord. Lordship will find page number 93. Regarding retrospective benefit of provincialization to the grade 4 employee, here, I'll, my lord, para 1. The consolidated list of grade 4 employee of ME, MEM, MBA schools received from DOs of 13 districts showing financial implication against each is enclosed herewith for favor of kind information and necessary action. The Assam Elementary Education Provincialization Act 1974 is enclosed herewith for favor of kind information and necessary action of the government. In the Act 1974, it was stated about all existing teachers and other employees of the school who have been appointed by the state government in their corresponding rank from the recognition period. On the other hand, in the year 1991, the government has provincialized middle school under two creation number. The government has provincialized 500 middle school by creation number show and show dated 16/11/1991 with chokidars, and by creation number show and show dated 16/3/1992. Government has provincialized 755 middle schools without the post of chokidar. Wherein, my lord, we are coming, my lord. Copies are enclosed. In the 755 schools, the service of chokidars were provincialized in the year 1996 by letter number show and show dated 27/2/1996. For the purpose, the amount required is show and show. Now, this is the schedule, my lord, table, my lord, of 13 districts from where the report was received out of the but now page number 95. In this regard, it may be stated that there are 755 number of middle schools which were provincialized without Chokidar by government letter as stated above. The requirement are not received from the 6 districts, namely Nalbari, Dibrugarh, Tinsukia, Hailakandi, Jorhat, and Shivsagar, and 3 DOs, namely Kasar, Kurajar, and Kamrup Metro, have submitted in improper manner in spite of repeated requests by this office letter as follows. Now, my lord, what happened? All the districts, they did not submit the proposal at the same
No, no, that's all right. It is apparent from the language of the
My lord.
letter.
My lord.
But you show me the decision of the government.
My lord,
to grant
there
the
is a
benefit.
minute, my lord. Your lordship will find page number 100. Now, my lord, page number 100, your lordship will find there is a minute, my lord. This is the minute. My lord, we are seeking for implementation. Minutes of the meeting held on 15/10/2019 in the office chamber of the Secretary, Elementary Education Assam, Elementary Education Department on the matter of providing retrospective benefit of provincialization of the grade 4 employee working in ME, MEM, MBA school. The following officers were present in the meeting. These are the, my lord, there was a committee meeting. The meeting was chaired by Srimati Bandana Datta Tamuli, ACS Secretary, Elementary Education Department. Welcoming the officers present in the meeting, the secretary asked Deputy Secretary, Elementary Education Department to explain about the background of the relevant grade 4 employee. Sri M. Gogoi, Deputy Secretary, elaborately stated about the matter. It is stated that government provincialized 755 recognized ME, MEM, MBA school during 1991 by creating the post of assistant teachers only, and the post of grade 4 chokidar were not created. Subsequently, government created 755 posts of grade 4 during 1996, and the service of the grade 4 chokidar employees of the aforesaid 755 middle schools were provincialized with effect from 27 to 1996. Although the grade 4 chokidar had been rendering their services for the period same as the teachers of the 755 middle schools, but they could enjoy monthly salary only with effect from February 1996. The grade 4 employees association have been demanding time to time to allow them retrospective benefit with effect from 19/11/1991. Matter was referred to Finance Department, and Finance Department asked to identify the number of such similarly situated grade 4 in all districts and what policies proposed to adopt for regularization of their service. Accordingly, after several correspondence made, Director of Elementary Education Assam has furnished particulars of 498 grade 4 chokidars out of 755 middle schools of 20 districts. Sri D.D. Sharma, Senior FA, and Sri Sanjeev Sharma, Senior FAO, questioned about the mismatching of the figure of relevant grade 4 employee for providing retrospective benefit. After threadbare discussion of the issue, it is decided to initiate the following step before resubmission of the proposal to Finance Department with policy decision. Now, my lord, the government, my lord, the first question will be what the 1974 Act, Provincial Act provides, my lord. The 1970, my lord, I'm not holding the book, my lord, so I cannot go through the provision also at present. So here the government said that 1974 Provincial Act provides that from the date of recognition, the employee, the person who are working in the school will be deemed to be the employee of that school, my lord. So here, what happened?
No, Mr. Islam, going by this letter,
my lord,
going by this minutes of meeting,
my lord,
can it be said that the government has decided to extend that benefit to you?
Yes, my lord, what is my case is that, my lord, there is a clear violation of Article 14 of the Constitution. Now, why Article 14 has been violated here in this
No,
case, my lord?
that's all right. There is a violation. That's all right. But you have read for implementation of this minutes of meeting.
Meeting, my lord.
So whether a decision is taken in this minutes to grant the benefit to you.
Yes, my lord, once the
Here
government,
only some steps have been initiated.
Well, once the government took a decision, my lord, policy decision, that policy decision should be implemented, my lord. That is the case. Otherwise, my lord, the petitioners service were provincialized in 1996. Now it is 2025, my lord. Almost 28, 29 years have gone, my lord. And most of the even grade 4 employees, either some of them have retired, and most of them are on the verge of retirement. And even, my lord, some employees have already died also, my lord. So, the benefit which the petitioners are entitled, otherwise entitled in 1996, my lord, that benefit, my lord, they are not granting that benefit even after 28, 29 years, my lord. Only they are taking decisions. And the only problem is here, my lord, because the government side is okay, my lord. Government side took decisions, my lord, directed all the districts to furnish their, my lord, the pro forma, their proposal.
So after this meeting,
My lord.
What happened?
Well, the only problem is, my lord,
They call for the report from the deputy commissioner
of all the districts.
Yes, and the director of elementary education will prepare the performa format, including the required information. Thereafter, what happened?
My lord, all the districts, they are not sending the report at the same time. Only 13 districts send their report.
No, that's all right. After this meeting, what happened?
My lord, no, my lord, that status, up to date status, that my lord,
Therefore, they are
only, my lord,
actively
the,
required.
my lord,
They file their
only, my lord. Otherwise, my lord, in the first phase, grade 4 employee, in the second phase, grade 4 employee, all are situated
No,
at the
that's all
same
right.
place, my lord.
You are entitled to it. Your right to equality is violated.
My lord.
But we decided to implement this Microsoft thing. You will get nothing.
Well, only the now the recent otherwise, even, my lord, the even while creating the post, my lord, of in the second phase, my lord, even the government directed to create the post. Lordship will find page number 24 of my petition. Government directed the director to create the left out post of 755 number of schools with effect from the date of the first phase school, my lord. Page number 24, your lordship will find. Creation of 755 post of Chokidar for 755 middle school provincialized with effect from 1911-1991. Now, the director was created to directed to create the post with effect from the first phase school, my lord. Same date, my lord. But the that was not done while creating the post, but it was done from the date, my lord, when, my lord, in 1996.
Yes, Mr. Soma will grant you 1 week time.
Lordship, 2 weeks, Lordship.
No.
Because
Already never do 7 jobs. Hard the is the burden for the part. Mr. Sharma, substance in the content side by the that it's a thing that obtain a copy of the for the support for harnessing paradise at the same thing to it. Better take the sub implemented part done with 1 week time. Is the matter started.
One last occasion, my lord, your lordship speaks today, Mr. R.K. Borpujari, is coming. R. Borpujari. Kumar to say. Kumar to say. Only, my lord, thinks a similar order was already passed, my lord. Same regulation of 30%, my lord. 1% left in paragraph number 4, my lord. So itu naik banget. Itu mungkin kita. Kita tuh naik.
Appears to be a secondary defect. Now, as per my lord, the Purnima Hore decision, my lord, secondary defects are entitled. Now here, my lord, neither finance nor education has filed their affidavit. Now since privacy, it appears, my lord, from the record. To dispose of this application, my lord, directing the authorities to verify within the time frame and my lord, extend the benefit.
Okay.
Because
So according to you, they are covered by the decision.
appears
Purnima Hora.
covered, appears to, we do not know. I am going by the record.
Yeah.
Prima facie appears to be covered.
Prima
So, yes, so legally there is no point on my part to fight it in my lord in place. But if lordship,
that similar order of this court.
my lord, some difficulty may arose, my lord, in some cases we have found, my lord, that honorable court process and order later on, my lord, some other things.
Already was coming through.
If mandamus is issued, my lord, then we are duty bound, my lord, to extend the benefit, my lord. But while, my lord, after the honorable court order communicated to the department, then on verification it is found that, my lord, what is spelled out the retribution that may not be correct to that extent. Then, my lord, complications arise. In the meantime, contents are filed, my lord, then to get back up. So therefore, my lord, if my lord, also maybe please to dispose of this petition and directing the authorities in the education department to verify and it is found that it is just happened, no one can stop us. It will be entitled. That is my responsibility.
No, Mr. Bora has on the other day furnished on decision of the court dated 28.
No, there are decisions, my lord, no, there is no quarrel, no denying the fact, my lord, there are decisions. But only, my lord, to give the authorities.
Mr. Bopuzari,
my lord.
contention is that they are also a direction of the court. To the respondent to verify the petitioner's particulars, and if it is found that the petitioners are entitled, that
because what I am concerned of, my lord, is the order annexed to the decree. Because in that order, my lord,
They complied to it. They complied already. Why were the, you see that? No, no, otherwise, my lord, if lordship, then we will proceed as per my lord. We are praying before lordship mandamus. Same set of persons, same select list, same regulation, on the basis of the honorable court's order, they already given. Only because of that, I am not coming along with them. So thereby they cannot deprive to me. I am praying before also mandamus, and they verify, no problem. They are employee, they must be verified. They are duty to verify.
Mr. Bora,
My lord.
so we done similar relief to the petitioners in this WPC number 699 of 2024.
Yes, 699 of 2020. Itu তুমি আছে তাই
So we are disposing of this.
Yes, my lord.
This is the
Prima facie appears.
Okay. Same order. How many petitions are here?
only one man.
One.
The others are connected.
They are already disposed of
Disposed
same way, same order, my lord. Your lordship go through it, my lord.
Okay.
Same order. So thereby that court, my lord.
We have not filed any application, my lord, so therefore we have made a honest submission. Point in getting accepted.
More orders, item number 7 and 8.
I appear to give the respondent. We are going to file our objection to the delay condonation.
You have filed.
We are going to file.
You are going to file.
May I please this matter be taken on 9th, Lord,
9th of?
9th of April.
Or Mr. Bhagavati learned counsel for the applicant. Appellant. Mr. Dubey learned counsel for the respondent. Opposite party Subsistence. The matter may be listed on 9th of April 2025, and in the meantime, you will file it objection. Here is according to allowed, let's submit the matter on 9th of April. And in the meantime, Mr. Dubey shall file affidavit objection. Yes.
Supplementary of 29 item.
Yeah, please, Your Lordship. This application is filed for striking out the name of respondent number 1, within bracket Lordship 2. She has already
Respondent number
1, 2, 1.2. Well, as she has already expired, and all the legal heirs are already represented. So her name may be struck out from the
respondent number 1 and
1, 1.2.
1.2.
My lord. From the area of respondent.
Nessa Ahmed.
Yes, Lordship.
She died.
Lordship. Case 8 is the death certificate.
Heard Mr. Khan learned from for the applicant, and also heard Mr. Pardon? Learned opted for the respondent number 1. And Patire 2 and 3. This interlocutory application under Order 1 Rule 10 of the Code of Civil Procedure is preferred by the applicant for striking out the name of the respondent number 1 and 2 from the array of the respondents in MSc Appeal number 271 of the state. Applicant referring to the Annexure 1 of the petition at page number 8. Annexure 1 of the application, page number 8, submits that respondent number 1, 2, Dupen Nisa Ahmed suffered demise on 9/1/2024, and her legal representative are already pleaded.
Yes, yes.
Already pleaded in the MSc Appeal number so and so and so. And as such, there is a requirement for striking of the name of the said respondent from the array of the respondent in MSc Appeal number so and so. The learned counsel for the respondent submits that they have no objection. They are taking note of the submission of learned counsel for the applicant and of the respondent opposite party. This court is inclined to support the application by striking of the name of respondent number 1, 2 for the array of the respondent in MSc Appeal number. Any order is required to be passed in the MSc Appeal? No. Service completed or not?
has been received.
Service completed.
Service completed. So today it is not listed perhaps.
So it will be in the month of April or May.
Or Mr. Khan, learned counsel for the insurance company is the appellant. Or the learned counsel for the appellant. That's the Khan for respondent number 1111314.
Yes.
And it's the party for respondent number 20. It is submitted at the bar and service completed. And LCR has also been received and the matter is ready for hearing.
Maybe in the month of
Provided that this is the matter
in the month of
for hearing.
in the month of May, Lordship.
Usual court.
Because only 40% your Lordship has directed to take payment.
Number 10 to 30 for hearing.
May I, my lord? I just recap, my lord. Whether I cannot ठीक होगा आई बोला अभी फोन कर in the instant case, my lord, what happened? The petitioner responded. Let me just recap, my lord, by this time. It will be. Petitioners are, my lord, the graduate teachers of the science graduate teachers of the upper primary schools. Initially, they have been appointed, my lord. What happened? They've been promoted to the post of, my lord, headmaster of their respective schools, my lord. At the time of promotion, my lord, they have not been given the promotional benefit. Promotional benefit, they are supposed to get the one increment, my lord. They have not been given. On the account that they are getting the same scale of pay with that of promotional post and the feeder post. The scale of pay for the post of science graduate teacher and the, my lord, headmaster are same. This is the issue, my lord. Their claim in this case, my lord, only to either to give MSCPS benefit, one increment, and or to give, my lord, the benefit of promotion. That's the thing. So as per, my lord, what happened? They have issued the impugned communication, whereby they have written that the petitioners are not entitled, the science graduate teachers are not entitled for any increment at the time for the purpose of promotion. Yes. My lord, it will come, my lord.
Customer software from the education department. The Catalonia has also some instructions, but not very.
Settled position is that, my lord, when a statute grants something, my lord, it cannot be taken away by a simple office memorandum or notification. The statute is the ROP 2017, my lord. It provides that, my lord, as per Rule 11, my lord, it provides, my lord, I'm just reading, my lord. I've given the earlier occasion, I've given the copy, one copy I have given, my lord, of this
ROP.
ROP. 11 pages, I have given 2 pages. Mm, mm. 11. I'm taking the retribution, my lord, 4917, 2021. 4917, 2021. Sir, my lord has got the ROP 2017.
Yeah.
My lord,
Page
rule,
number 49.
page number in this book, my lord, book is different, I think.
Yeah.
Page number 311, it's a government my lord, gazette page number, and the rule is 11. Fixation of pay on promotion on or after first day of April 2016. In case of promotion,
Rule.
Rule 11, my lord. Headline is, my lord, a fixation of pay on promotion on or after first day of April 2016.
Page number. This is the. Oh, yes, that's the report. Furnished by him. Yes, yes, in that case, okay. So it will be 311.
Lordship will take my book then.
Repeat the lottery, it is page number is in the right hand corner. Top. 311. Yes, fixation of pay on promotion.
Yes, Lordship. In case of promotion from one post to higher post on or after first day of April 2016, the fixation of pay of a government employee shall be made in the following manner. A. One increment equal to 3% of the sum of the existing pre-promotion pay in the pay band and the grade pay corresponding to the pre-promotion post shall be computed and rounded off to the next multiple of rupees 10. This is relevant one. In case of promotion, minimum one increment at the rate of 3% is everyone is entitled. And my lord, when there are post having feeder post and the promotional post are bearing same scale of pay, at what to do in these circumstances, my lord, that is given in the FR 22, my lord. I've quoted in the, I've annexed the relevant, my lord, pages of the FR 22 in the read petition. 414917. Page number, my lord, 94.
Of the effort.
No, my lord. It's in the read petition. Read petition. Annex 13. FR 22.
Yeah.
Notwithstanding anything contained in these rules, where a government servant holding a post in a substantive, temporary, or officiating capacity is promoted or appointed in a substantive, temporary, or officiating capacity to another post carrying duties and responsibilities of greater importance than those attached to the post held by him, his initial pay in the time scale of the higher post shall be fixed at the stage next above the pay notionally arrived at by increasing his pay in respect of the lower post by one increment at the stage at which such pay has occurred. This is also given in the FR, my lord. In the government of Assam, my lord, in the year 2014 has issued one office memorandum. It is at page number 95 to meet up such, my lord, situations. Finance Department has issued it under ROP 2010, of course, but the situation prescribes. I'm reading. Matter relating to exercise of option and implementation of note below Rule 11 of Assam Services ROP Rules 2010 in regard to refixation of pay. It appears some confusion has arisen in connection with implementation of Note 1 below Rule 11 of the Assam Services ROP Rules 2010 regarding refixation of pay in case of option exercised by a government employee on promotion to the next higher cadre post. In view of this, in consideration of the actual purpose of option exercised by a government employee for refixation of pay on promotion of the appointment of a higher cadre post, as regards implementation of Note 1 below Rule 11 of Assam Services ROP Rules 2010, in reference to the provision of FR 22 1A1, read with the Rule 14 of the Assam Services ROP Rules 2010, the matter is clarified as follows. In case the government employees opts to get his pay fixed from his date of next increment then on the date of promotion, pay in the pay band of the lower post, pre-promotion post, shall continue to be unchanged, but grade pay of the higher post, promotion post, shall be granted. Further, refixation shall be done on the date of his next increment, that is, 1st day of July. On that day, such a government employee shall be granted 2 increments at 3% rate. One due annual increment shall be granted first on the basic pay, that is pay in the pay band plus grade pay of the lower post, oblique pre-promotion post, and the second on the account of promotion, which shall be calculated on the basic pay arrived at after granting his annual increment in the lower post, oblique pre-promotion post. To illustrate the point, if the basic pay prior to the date of promotion was rupees 100, first increment would be computed on rupees 100 and the second on rupees 103. Then the relevant grade pay of the higher post, oblique promotion post, in the relevant pay band shall be allowed, excluding the grade pay of pre-promotion post of or lower post. That is, my lord. Apart from that, my lord, the ROP 2017 has provided MSCPS. Earlier it was SCPS. SCPS concept was modified in the MSCPS. Earlier there were 2 increments, my lord, and now it is 3 increments. After 10 years of continuous service, if an employee is not getting any promotion, he is entitled to financial upgradation by at the rate of 3%, additional 3% after 10 years. So, my lord, there is in lieu of the promotion. In either way, my lord, the petitioners who are here, my lord, all of them have completed 30 years of service, my lord. And they are also otherwise entitled for 1 increment under MSCPS scheme. This is also statutory scheme, my lord, under ROP 2017. Here the impugn, my lord, communication. It's at page number 89, my lord. There are 2 impugned communications. I am taking first to the page 89, my lord. There was 1 round of litigation by different similar situated candidates, my lord, teachers. And the Honorable Court has directed to take into consideration their representation. That representation, my lord, taking the recourse of the Finance Department recommendation, my lord, that is rejected. The grant, the benefit of the promotional benefit, the consideration of promotional benefit has been rejected by the department. Through this impugned, my lord, order dated 10th May 2019. And my lord, another communication at page 82 has been issued by the Undersecretary of the Government of Assam Finance PRO Department to the Treasury Officer, my lord, Silchar. It is stated, subject fixation of pay of headmaster oblique headmistress. Reference your letter number such. With reference to your letter above, I am directed to inform you that there is no provision for benefit of 3% increment as promotional benefit to headmaster oblique headmistress of ME, MB, MEM schools who are promoted from the science teacher. However, there is a provision for provision in the Assam ROP rules 2017 special allowance to headmaster oblique headmistress of ME, MB, MEM schools. This issuance of this letter is absolutely illegal, my lord, because the statutory provisions of the ROP 2017 has specifically stated it is for all in general, my lord. There should not be any specification of a post, my lord. It is the general provision specified in the ROP, my lord, and as per that provision of Rule 11, my lord, 11A, every employee who is getting promotion, my lord, he is entitled to 3% promotional benefit. And additional 3%, number 1. Number 2, ROP FR 22 has also specifically stated that, my lord, if the post is having the higher responsibility, then the incumbent concerned is entitled to one increment. On the other
Yes,
hand,
sir,
my lord,
Mr. Gogoi, what is your stand? Have you filed your affidavit?
they have filed, my lord. They have
Affidavit we have filed.
They have
But
filed.
whatever my learned friend is arguing, okay, my lord, it's heated case because we file our affidavit whatever on the basis of the amendment made in the paragraph of the report. Shortly we'll see, my lord, para 21, para upon this annexure 13 has been relied upon. If we can show that he has mentioned anything, whatever he has submitted, it is there, then of course, my lord, he can treat this case. But without making an environment first, just enacting some document, whether he can argue this point. Not the end of it, also may kindly say that I was checking, my lord.
FR 22 I have given, my lord.
And
It is-
also will see that FR 22C.
Yes.
ROP says FR 22 1C or 1A. 1A1, not 22C. Lordship will see page 94 for a moment, madam. I was referring to FR 26. It's not FR 22, it is FR 22 capital C.
Yes, that I have
So he
enacted.
cannot, my lord, modify it on his own. Ma'am. Very specifically mentioned, ma'am.
Page number 90?
94
Yes.
of the petition.
Yes.
Lordship will see FR
FR
22C. It is very categorical. ROP rule says it is FR 22 1A small a Roman 1. How can 22 FR 22C be relied upon, my lord, referring to this particular provision of ROP? ROP Lordship will see, my lord, that on page 311. The rule number 11.
Yes.
In case of promotion from one post to a higher post on or after the first day of April 2016, the petition of pay of a government employee shall be made as per FR 22 1AI, not FR 22C that is pointing out. Lordship will see, there will have to be, he has not placed the entire FR 22. He
It
has
is-
placed only FR 23. It is FR 22 1AI, which has been mentioned in the ROP 2017. Sir. So this particular FR 22C will not be applicable in view of the, my lord, rule number 11 of the ROP 2017. My lord. It is this contention here relied. Firstly, he has placed the FR ROP 2017, rule number 11. Then he is referring to FR 22C. But 22C has not been mentioned in FR, my lord, ROP 2007. You have to be specific. When it says, my lord, FR 22 1AI, then he will have to place that particular part of FR, not my lord, FR 20 on his own.
My lord, legal provision, your lordship can take judicial notice.
Relied upon, my lord, the ROP 2017 rule 11.
That I am not relying in that sense, my lord. I am relying in the sense that for the purpose of explanation. Explanation. The rule is there. Rule is there. Already rule has specified. And I'm just relying the office memorandum only for the purpose of explanation what they had given under the ROP 2010 when it was in force. Only to show that only that I have relied upon. That office memorandum cannot be acted upon now because already 2017 ROP has come, and that 2017 ROP also, my lord, specifies it incorporates this provision. That only to show that I have annexed that, my lord. Under ROP 2010, they have issued this office memorandum to clarify the actual position, my lord. They have issued this office memorandum. And the ROP 2017 already takes this into consideration in the Rule 11, my lord. And what my learned friend has stated, I have not pleaded. Everything, my lord, regarding MSCPS benefit, I have pleaded at page 29, my lord. Page 20, I have given, my lord.
Mr. Gogoi, if it is there in the ROP 2017, why it is not being placed?
That is his contention, my lord. Placing that he is relying on FR 22C. I am saying, my lord, he will refer to FR 22 1AI or the Roman 1. To place that and then argue, my lord, because he cannot now.
All right, but according to you, whether they are ended or not?
Not entitled, my lord. That we have referred to, my lord. We have stated that.
Where you have stated in your affidavit?
No, so far as FR 22 1AI, whether that he is entitled, where is that pleading, my lord? That's why I am saying there will have to be some amendment in the repetition. Against which we will reply in the affidavit of position. There is no amendment.
Otherwise, you tell me, otherwise, whether he is entitled or not.
That's
As per
why,
this ROP.
no, ROP 2017, my lord, he is being a, my lord, regular employee. It will definitely be applicable to him.
Yeah.
But here, my lord, so far as my lord, particularly referring to this particular provision, whether his case has been considered or not, that I can reply only on, my lord, there is a specific amendment. Or there is a query put forward by this honorable court today. It is not there otherwise in the pleadings. Otherwise, it should have been there in an affidavit in opposition. We would have countered or we would have agreed to that. Since there is no pleading, we have countered to whatever statement is there in the petition.
That's all right.
Readings are there, my lord. If my learned friends,
Yes, yes,
I will read, my lord. Paragraph 20, my lord, page 27.
It's about
Yes.
That the petitioners beg to state that the government in the finance department has introduced the concept of modified assured career progression scheme through the ROP 2017. As per the provisions of the above scheme, one employee serving in the same post for a period of 30 years without any promotion would be entitled to the benefit of 3 numbers of financial upgradation every 10 years of his service. The petitioners who have been promoted to the post of headmaster of the upper primary schools have been deprived of their legitimate claim of one financial upgradation on the ground that they have been granted promotion to the post of headmaster of upper primary schools. On the other hand, the respondent authorities have not granted any sort of financial benefit to the incumbent promoted to the post of headmaster. Unless the financial benefit comes within the purview of the basic pay, the same cannot be treated as promotional benefit to any incumbent. Special allowance is not a promotional benefit. The concept of special allowance cannot be treated as promotional benefit because the incumbent concerned would not get any service benefit nor would get any pensionary benefit out of the special allowance. Whereas had the incumbent would not been promoted to the post of headmaster of the upper primary schools, in that event, the incumbent concerned would have been granted the benefit of 3 financial upgradation as per the provisions of MSCP scheme 2017. The promotion to the post of headmaster of upper primary school in respect of science graduate teacher has become a misfortune for them. Unless the promotional benefit, either such as incremental benefit or higher grade pay benefit, is granted to the incumbent of the headmaster of upper primary schools, the incumbent concerned would be highly prejudiced. Moreover, the fundamental rules such and such mandates for granting of the financial benefit in the event of promotion to the post of higher level. The relevant portion of the above rule is quoted here and below. That I have already stated, my lord. In one pair, I have everything I have stated, my lord. In the response, what they have filed, my lord, they have stated that we are getting the special allowance, my lord. Special allowance, even who is not promoted, holding the in charge, my lord, he is also getting. Special allowance cannot be treated as a promotional benefit. It doesn't come within the purview of the basic salary. Unless and until within the purview of the basic salary something is added, my lord, it is not the promotional benefit. Allowance, my lord, it is for time being. It goes after every 10 years. But the basic salary, when it is included, my lord, it remains till his retirement and after even in the pension. Grade pay plus pay band, my lord, includes the basic salary. And over that, 3% will come within the basic salary part. Unless and until the 3% is added with the basic base, my lord, his whatever benefit, even if he gets as allowance, my lord, allowance will not last, my lord. Allowance will come to an end. It is only for the time to time decision of the government. This is not the basic salary. Promotion includes the, my lord, financial benefit in the basic salary. Therefore, the ROP has stated, my lord, 3% benefit should be given at the time of promotion. What they have done, my lord, they have, my lord, stated that we are not entitled for any promotional benefit, science graduate teachers. On the other hand, while the time has come for granting the modified assured scheme, my lord, MSCPS benefit, they have stated you have been promoted, therefore you are not entitled for MSCPS benefit. In the promotion, I am not getting anything. On the other hand, at the MSCPS, my lord, I am not getting that. That cannot be. Even issuing a office memorandum or impugn letter, my lord, statutory right of an employee cannot be taken away. Settled position.
He is entitled to any one of them.
No, my lord, the MSME says, my lord, the scheme he has already annexed. Possibility that, or my lord, page 141 of our affidavit issue of it has come into effect in from my lord, April 2016.
124.
Yes, my lord. Page 141, my lord. Modified issue. In WPC, my lord, 4917 2021. Page 141.
Yes.
My lord,
This
this
could
is the
dated 6th of
modified.
July.
Yes, my lord. 6 July 2017. This is the modified issued career progression scheme. These are the various provisions. Now, Lordship will see the chart. 10 years, my lord, after completion of 10 years without promotion. Lordship will see number of promotion, ACPS benefit, MSCP benefit avail. None, one increment. If there is one promotion, finally entitled benefit that can be granted, none. After 20 years, if there is no promotion, my lord, two increment, he will get two increment. That's the first one and the second one. Now, my lord, say, my lord, ACPS benefit, he has got one. Then in that case, he will get only one increment. Now, my MSCP benefit availed, already availed. Then none. After 30 years, no promotion. Then three increments he will get. For 30 years, my lord, if he is continuing in the same post, that is the post of my lord, graduate teacher science or graduate teacher, in that case, he will be entitled for three increments. Here, he has been promoted in 2018 or 19. They have been promoted. So, whatever is there, my lord, pursuant to the promotion, they have been given one increment. Not a, my lord, higher pay scale. Usually, it is given. But there is no settled law that moment you are promoted, a particular scale, higher scale will have to be given. If you can place that law, because I have got a judgment of the Supreme Court says that promotion is not always accompanied by a higher pay. It can be by a pay allowance. It's up to him to accept it or reject it, knowing fully well he accepted the promotion. Man. It's not that he has been forcefully given the promotion. Otherwise, you would have got this manner after 30 years, you would have got three increments. Now his case is that his other counterparts who are working as a graduate teacher, they by getting three increments, they are getting higher pay now. By accepting my lord this particular benefit of my lord MSCP, that he is not getting. In between because he has accepted the promotion, where only the increment is there, higher scale is not. That is his my lord precise case in the entire petrol. By getting a promotion, he has got a lower scale, whereas my other counterpart, by having the MSCP and all, getting three increments in 30 years, they are getting higher scale. And his case is that on the day when he was promoted, he was holding the same grade pay and the pay scale like that of the graduate teacher. And after the promotion, only the 300 or 400 that amount has been given. So he is at a loss after getting the promotion.
It is not about to
No, my lord, law is settled, my lord. Because knowing fully well he has done, not that suddenly we have given it. This came into force, Dorsey will see page 140. They were promoted sometime in 18 and 19. ROP rules by the page 140. This is the notification on behalf of the governor. This says in the exercise of powers conferred by the proviso to Article 309 of the Constitution of India, the governor of Assam is pleased to allow special allowance to the following notified categories of posts and rates shown below with immediate effect. Serial number 5, Lord Civil. No, 12. Headmaster of ME, MB, ME school and senior basic school. These are the group APC, these are the various groups. So this is what they have got. And this is in the ROP rules now. This notification is under Article 309. And this has not been put to the list. He cannot say that I should get higher than whatever has been given under the ROP rules 2017. He will agree by that, he will have to challenge the ROP rules. That this has not been provided, this particular pay scale and this allowance, whatever is given is bad in law. Only then this honorable court can interfere and direct the authorities to give a higher pay or may refer it to a special committee. Because these are expert committee who decides pay commission and all, they are expert committee. This honorable court under my lord 326 does not have the expertise to my lord decide whether a particular category of person must get a higher pay or lower pay. My lord, these are settled law. Lordship is aware, my lord. Lordship was there in the administrative side also, my lord. These are proposals which are submitted. Their proposals are submitted before the pay commission. They used to recommend, and that recommendation is also not binding upon the government. Up to the government who will finally accept it. Only then the ROP rules come. 309 rules. Now, if he is aggrieved by whatever allowance he has been given after the promotion pursuant to the ROP rules 2017, then he will have to challenge it. By just making a submission before the honorable court, this ROP rule cannot be held to be a bad law. Because whatever they have been granted by the education department is following ROP rule 2017. You will have to show that this rule is bad. Whatever by which he is getting the benefit, he will have to specifically challenge that particular provision. Without challenging that, my lord, even if he raise whatever evidence he has before the honorable court by affidavit or my lord in the decision, whether this honorable court can adjudicate without having a specific prayer or relief to that effect that that particular provision is bad of ROP 2017. And again, that will be within the jurisdiction of the my lord division bench. The moment rules, challenge of a rules or provision comes up, because tomorrow if this honorable court holds that they must get a higher pay, we will have to amend the ROP rule, meaning thereby that ROP rule has been interfered with. Whether this honorable court can, my lord, I think, considering the High Court rules, my lord, can take up this without, my lord, there being a specific attached to that. Of course, my lord, he has the right to challenge if he is aggrieved. If he is aggrieved by the way the proportional benefits are being given to him after the promotion. If he feels that he will have to challenge it. Because this notification is says, my lord, 309. This is a rule, my lord, by the assembly of the honor of this country. He will definitely will have to hear and read it.
I will counter my learned friend's argument, my lord. My lord, my learned friend has submitted, my lord, many things, my lord, only to confuse the court, my lord.
Same thing he is also doing, my lord.
No. I am not doing that, my lord. I am not doing that. I'm making just simple. Already ROP has given the benefit. Why shall I challenge, my lord? Question of challenge does not arise. I am entitled to the increment as per rule 11 of the ROP. Why shall I go for challenging this, my lord? Allowance, my lord, even if I am given the benefit, allowance will continue. Allowance will not discontinue. Allowance is only for buying chalk and duster, going to the office. As a headmaster, I am required to go to the office. Only for that satisfaction, allowance is given. Even if I am not promoted, your lordship may take information. Even without promotion, every teacher who is holding the charge of the head of the institution is getting the benefit. Even from the LP school up to the high school, my lord, all are getting. Yes, my learned friend can inquire with the office, with the my lord, the teacher concerned, school concerned. If I am wrong, I will surrender, my lord. I am not wrong. Even if without the promotion, LP school teacher are getting the benefit of allowance, my lord. I am not wrong. My learned friend is confusing. Even if I am given the benefit of my lord 3%, I will my allowance will continue. It will not stop because the additional benefit allowance cannot come within the purview of the basic salary, my lord. This is the basic concept of the ROP, my lord. Even if, my lord, I am granted benefit, my allowance will not discontinue. It will continue. This is for all, whoever in charge, whoever regular, irrespective of this concept, my lord, is getting. I am entitled to, my lord, promotional benefit or MSCPS benefit. That they cannot take away by issuing the simple letter. How they can take away, my lord? This statute has given benefit to all the incumbents of the state, my lord. Whoever completed 30 years of service are entitled for 3 financial benefit, upgradation at the rate 3%. Whoever promoted is entitled for one promotional benefit 3% additionally. Who can take, my lord? Either of this is I am entitled. This way or that way. They cannot say, my lord, on the one hand, I am promoted, I cannot get the benefit of MSCPS. And on the other hand, I am getting the allowance, so I am not entitled for 3% for the purpose of promotion. That they cannot say. They cannot take the stand. Absolutely wrong.
No, it's a order.
Yes, Lordship. Last occasion, I have given your Lordship's order. One petitioner has also got my note. I have given the order. Your Lordship will already acknowledge that. Already I have given. Let me just read one petitioner. And some petitioners in the service book, they have been given no promotional benefit. That also I have given, my lord. Last occasion, your Lordship is kept on record.
So, Gogoi, which letter you have referred to? That's 309.
This is, my lord,
Page 140.
page 140. This is allowance, my lord. In exercise of Rule 11, two of the petitioners have been granted the benefit, my lord. That order I have given last occasion. And in respect of other districts, my lord, they have not been given this benefit. That also I have given this service copy. That I have got only one copy just now. Yes.
In that case, if the petitioner has got this benefit, my lord,
All have not got, my lord.
then we will have the instruction, my lord. He cannot.
Last
now
occasion,
refer to the court in this manner. He has to file an additional affidavit. Make a categorical statement that yes, so and so petitioner out of this series, he has got the benefit. Then of course we can have the instruction.
Last occasions, my learned friends in the education department has taken time to take this instruction, my lord. Actual position.
Let him file an affidavit, my lord.
Why shall I, my lord, go on filing affidavit, my lord? Petitioners, some of them retired, my lord. I have already stated in everything in my affidavit, in the reply and the writ petition, my lord. Every aspect of the case I have pleaded, my lord.
I have not seen it on the record.
I will give the Xerox copy, my lord. After this. অশোক দত্ত রিটায়ার করলি মানে অশোক দত্ত তোমার দিয়ে একটু লই যা
No, Mr. Prokhay, so we
Lordship.
cannot ignore this notification also.
Yes,
18th of
Lordship.
July 2017.
Yes, Lordship. We cannot ignore because this is additional benefit given to all whoever not in the charge of the whoever in the charge of the headmaster. This we cannot ignore because this is additional benefit. This is not a promotional benefit. What is allowance, my lord? This is given to all whoever in charge. Without promotion, everybody is getting well.
Sir Gogoi, some of the petitioners officers have already been granted benefit.
No, my lord, they are headmaster. Not, they are headmaster. According to the petitioner, following Rule 11 of the ROP 2017, that 3% increment has now been given. That is there in the calculation. I've seen it, my lord. If that is given, my lord, if the education department will have to clarify. My lord, ROP rules we have published. It's up to the other departments to come implement it. If two petitioners, my lord, out of this, my lord, various batch of petition, they have got the benefit. And others are also equally placed, my lord. Of course, they must also get the benefit. I am not against that, my lord. But whatever document he has placed over the board, my lord, now, without having copy to us, my lord. Let us have the clarification in that case. If this is right, my lord, also get. We are not against this, my lord.
Furnish a copy to them.
Last occasion, I have last occasion,
Lordship,
my
if
learned
we get
friend
the
was supposed
court's
to.
order, my lord, about these two documents, then we can have the instruction.
Last occasion is
At least
already
this
this.
court record by way of order of the honorable. That can be part of the.
Last occasion is already placed, my lord, and my learned friend has been asked to place this instruction.
Sir Katunia, have you received?
Last order may be perused, my lord.
The only thing is, was if the Ashok Datta petitioner, he got the relief, why is pursuing the petition?
He is not the alone here, my lord. He is the
That's
is
my
a
lord.
joint
My lord,
petitioner.
if he is got the relief, my lord.
His name can be struck off, my lord. It's no problem, my lord. No problem. Yes, sir. He has got the relief. His name may be struck off. My other petitioners pursue, my lord. It will continue. It will be immaterial whether his name is there or it is deleted. It will not change the merit of the case, my lord.
So what is your instruction now?
As regards this, I have not.
No?
Oh. They have, they instructed the doctor to make an inquiry letter. That inquiry report is copied.
Well, I will also have instruction specifically whether under Rule 11 of the allocation of 17, the petitioners herein who have been promoted subsequent to my lord 1st of April 2016, as mentioned in the Rule number 11, whether they will get that increments and all. That I can have the Rule 11, my lord, that one, my lord, that rule has been-
And also that instruction, my lord, whether the teachers who have not been promoted are getting the benefits of the allowance, my lord.
That is a
That is also important, my lord, because they are submitting, my lord, that as I have got the allowance, my lord, we are not entitled promotion.
Page 140 is very clear, my lord, that there is no provision for in-charge headmaster and in-charge principals to get that. Doctor will see that, my lord, page 140 again. Somebody is getting, that's a different issue. The authorities will take action again. Ma'am.
Not somebody.
Page 140. The designation, the posts are being given, ma'am, from serial number 1 to 12. There is no in-charge post. Ma'am. These are specific, my lord, principal, headmaster, whoever is there. They will have to be promoted first to hold this post. In-charge is a, my lord, temporary arrangement. Till the vacancy is, my lord, filled up. Supposingly, my lord, there is a higher scale attached to the post of headmaster. A in-charge assistant teacher who will be holding the charge for a say a month or till the post is filled up. He will not be getting the, my lord, higher scale. He will be getting the same scale that of the, my lord, assistant teacher only. Additionally, he will have to do the duty of a headmaster.
The thing is that,
Okay,
my lord,
Mr.
my learned
Professor,
friends.
let them apply respect of the order.
And also, my lord, regarding allowance, my lord, grant of allowance, whether without promotion, the teachers who are in charge in the high school or ME school, my lord, or LP school, they are whether they are getting this respective allowance or not. Even the to my information, I can produce the salary statement of the teachers, my lord. Even without the in charge teachers, I can produce, my lord, getting this allowance. If my learned friend insists, my lord, I can procure this.
Okay, you produce it.
Yes, sir. Even with the promotion, they are getting.
So go for last number.
What a finance department.
Finance department and Mr. Katonya for the elementary education department. During the course of delivery of Mr. Procedural has particular order of the deputy inspector of the current. So, and perusal of the same indicates that 3% increment, promotional increment has been granted to Sri Asok Dotto, who is the petitioner number 1 in WPC number 4917. 4917. Mr. Gogoi and Mr. Katone are learned contact for the respective departments of instead. They may be granted some time to obtain inspection in respect of this order dated 12/2/2021. Accordingly, it is provided that Mr. Professor shall furnish a copy of the order dated 12/2/2021 both Mr. Gogoi and Mr. Katone, so as to enable them to obtain necessary inspection in the respective departments and to place the same before this court on next day. This is the matter on when.
In detail, also make it, my lord,
Will give us some time, and we'll have to see the
as per their convenience.
because in my lord, the second week of April.
Second.
No.
Yes.
Obliged.
So the petitioner, some of the petitioners have already retired.
Yeah, of course, my lord, others will get the same benefit, my lord. There is no doubt, my lord. Provided they are getting it legally. That instruction will
Of
have.
course, that of course. My lord, I will take the copy of this. my lord.
You can.
Yes.
Please, your lordship, kindly pass over the letter for the day.
Inform it earlier also. I have been waiting for all day.
Actually, my senior came to court to do the hearing matter, but suddenly she felt unwell. So leave the court.
For new vacation.
After the agreed by suppose the party.
Lordship, one more item is there. Item number 19.
Item?
Item number 19.
Like it. Who is for the response? You inform the other side. Did you inform the other side?
No, Lordship.
You inform the other side? Complaint? We will grant you adjourn. No problem.
Obliged.
But they also have on last occasion, also has recorded a statement that if they are not present next time, Lordship will not consider if they have for example. This simple case of the plaintiff has responded as a plaintiff and sued for 60 purpose of contract and sued as an appeal at the appellate court. And thereafter they have filed the appeal. They stay order and they enjoy. Last occasion, Lordship has recorded it.
That's all right. Observation is there. Failing to its necessary order will be passed. Who is the council then for the
Lordship R. Islam. MP Ahmed.
or Islam? Have you seen the court today?
Lordship I don't know.
You have not. Can you fix this sorted? On that date, if the current payment
Lordship on my humble prayer is Lordship may not dismiss for default. They order to be written. Then they will come. But they are observing. As per my they are observing from outside. Because they have made the case. This is a case like this. I have paid some amount at the dedicated position that there is a contract for sale of the land. At the time of distress, he has taken the money. Thereafter, he refused to execute the sale deed. I have filed a suit after issuing notice demanding execution of the sale deed. They have admitted in their WS that they have accepted the amount. But they are not in a position to make the payment, execute the sale deed. And this is the case. And
What is the stay order?
Stay order will find it on 29/7/2016. This is very simple. Only specific.
That's all right, but if the other side remain absent, we cannot decide the issue on merit.
Merit. Only we can dismiss this case for default.
Order is passed in which petition? RS, IA.
Okay, IA.
Sir, let me check. Non-appeal to the appellant on both. However, Mr. Goswami ordered to the respondents present. Mr. Goswami referring to the order of this court dated 11/3/2025 subset. On that day also the appellant remained absent and the court was pleased to observe that failing to present on next day necessary order will be passed. And as today also the petitioner appellant remain absent, Mr. Goswami contended that the interim order, who is the appellant herein enjoying person to be granted by the order dated 29/7/16 may be vacated. But taking note of the submission of for the respondent, and also considering the fact that on two consecutive days the appellant herein remain absent without any representation. This court is inclined to vacate the interim order dated 29/7/2016 in I number 291 of 2016.
This is the court date for hearing.
This the matter part of
Number 18. 18.
Lordship, in item number 19, no, item number 19. We have taken consent from the other party today itself.
your
for
name,
adjournment.
please.
Yes, Lordship.
Your name.
S. Ajmi, on behalf of R. Chaudhary.
S.
Ajmi.
S. Asmi learned counsel have been on behalf of Ms. R. Chaudhary, learned counsel for the appellant. With consent from the other side, press to the matter. When
Any date, Lordship.
after vacation.
Number 18.
Yes. May I object to it? I have got an appeal and lordship in this RFA. I have not seen the council order now. Okay.
Pardon?
Lordship, actually, lordship, what happened? Yeah, the case was listed before Honorable Justice P.J. Sokia, sir. He asked me, as he could not go through the cross-examination part, so he.
After that copy of
But I think Your Honor is in a position to go through the cross-examination.
So,
Particular language, lordship.
last order is
one court would not go through it and I can go through it. Huh? What kind of topic?
I beg apology, lordship.
It is in vernacular or in English?
It is in vernacular.
Vernacular.
last order is for submitting the
Last order.
before.
At page number?
Lordship,
Is it,
in LCR. In LCR. The appeal memo is not in vernacular, lordship. Everything is in English.
Evidence of witnesses.
Evidence of cross-examination of the witnesses.
Cross-examination of all the PWs.
PWs and DWs.
So what was the order of this court?
For submitting the consulted type and
So about a year back, you have been granted time to translate the cross-examination of the.
I beg apology, lordship. A last chance may be given to me. I will translate it.
Third, sir, if it's not a learning appellant, that do that learning two. Two or one?
and two.
Two.
No. Two. One.
One.
I'm for the
That's for that number one. And for two, non-appeals for the respondent number two. Mr. Sorba, learned counsel for the appellant submits that though high order dated 6/6/2024, this court was pleased to direct him to get the documents translated from vernacular to English. He could not carry out the order and price for granting him one last chance. Here is accordingly allowed. Leave the matter immediately after reopening of the viewing.
Highly obliged.
23, 22 and 23.
None appears for the applicant on call. How about Mr.
Respondent number 6, 1 and 6.
Respondent number 6, 1 and 6 to present. Later matter after vacation. The event of subsequent non-representation of the petitioner, appropriate order to follow.
Please, Your Lordship. Learned counsel has, he was on his way. He's not. He is yet to reach the court. He's on his way. He may give an adjournment.
I could not follow.
Learned counsel is coming, but he is not yet reached the court. May be allowed to.
Art, sir?
R. Lohakar.
R.
Lohakar.
R. Doctor, learned counsel appearing on behalf
R.
of
Sensua.
R.
Sensua.
R. Sensua, learned counsel for the appellant and Mr. Diego Boy, learned counsel for the respondent.
Number 1 to 5.
That's number 1 to 5. The learned counsel appearing on behalf of R. Subsistence. So Mr. R. Sensua is on the way to the court. He may not reach the court in time and tries for stand over the matter for the care of basically the matter after begging.
May I please, Your Lordship? I am very sorry, Lordship. I am in the different courtroom. I am for 22 and 23.
Letter learned counsel for the
Emroy, for the petitioner.
appear. So when do you want?
On before Bihu? After Bihu? Okay, no problem.